16. I'm appealing for the respondents. On last occasion, this honorable directed me to produce the original records. But unfortunately, that records have not reached me. May taken after puja vacation. I have already taken consent of the council of the appellant.
You have taken the consent?
Lordship, I have taken consent.
Okay, on request made by Mr. S.C.K.L. From the standing council,
Custom lords.
customs. List the matter after the judge.
Lords.
Maybe I beg to man with the due concern of the other side, my lord. Item number 21, my lord. The matter after vacation, my lord.
You are 40.
Appellant, my lord. And my friend is the respondent, my lord.
The private respondent.
After puja.
After puja. Any date your lordship may fix because my senior friend has a problem today.
Any date.
On request made by Mr.
HL, my lord.
H.R.D. Chowdhury.
No, HR.
Oh,
H.R.D.
H.R.D. Then council for the other. You want a date fixed?
I'll leave it to your lordship. It will be better with the matter. And they are very small.
Okay, 24th October.
I'm grateful.
May I please your lordship, with the consent of the other side, I would like to mention item number 2, 6 and 7. It may be 2, 6 and 7 of the same series linkage.
These are all
Same.
connected matters.
Yeah,
2 to
yes,
7,
lordship.
2 to 8.
Yes, lordship. So it may be listed.
Lordship, in item number 5 IPL, Lordship, we have some urgency because Lordship, the writ petition number 1 has already retired. And the writ petition number 2, Lordship, is also going to retire early next year. Lordship.
Yes.
Senior Standing
Yes.
Council Rajesh Mojumdar is also not available, Your Lordship. Then matter may post it as he is
24th
24.
out of September. 9.
24th.
Okay, on request made by Mr.
JP Burua.
J.B. Barwal, Learned Counsel for the petitioner in WBC number
2, 6, 7.
item
Two,
2, no?
Petition.
Repeat with the 8682
8682 of the
19 5992 2019.
list the matter on 24th September.
Deeply obliged.
2 to 8. Command order.
May I please your lordship, I like, with the consent of the other side, I like to mention item number 11. The senior counsel D.N. Panda from Orissa was supposed to argue the matter, but he had went through open heart surgery and doctor had advised him not to travel. So he had prayed for adjournment, your lordship. And kindly the matter may be listed in November, your lordship.
Okay, on request made on behalf of Mr.
P. Sharma, on behalf of petitioner D, on behalf of D. Sharaf.
Okay, on request made on behalf of Mr. D. Saraf, then senior counsel for the appellant. List the matter. When do you want?
In November, your lordship.
Okay. In the month of November.
Obliged.
Or if I pray for listing of a matter for appointment under compensated ground, as the DLC meeting will be held on 18th of this month. So it has been instructed to the petitioner to get the case disposed of, or some instruction may be given to the, otherwise her application will not be.
This is a single bench matter. This is a division bench matter.
Single is the division.
Single match.
Then you have to mention before point number 3.
Lordship, I beg to mention for listing of a division bench matter, Lordship. Lordship, matter pertains to the compassionate appointment. And the matter has already been listed in the regular hearing list, Lordship. So I pray for some early date because SLC meeting is going to be held last week of this month, Lordship.
Dismissed on what ground?
Because the petitioner doesn't possess the required qualification. Instead, in spite of being graduate, Lordship.
Single judge disposed it of on what ground?
Single judge disposed of on the ground that he doesn't possess the required qualification.
Is it for hearing?
Lordship?
Is it for hearing?
Lordship, yeah.
Okay, next week,
Next week, Lordship. Obliged.
19th.
May I please, lordship. First, I beg to mention number item 19, 18 and 19. 19 and 20, yes. 19, 20, lordship. Consider that has been taken, lordship. The date of the month of November, lordship.
You are praying for?
And 19, I'm appealing for the appellate.
Your good name?
B Sharma.
Okay, on request made by P. Sharma, London Council for the appeal, with appeal 333 or 333 of 2022. Release the matter in the month of
November any date, Lordship. 19 and 20 take together. Lordship, 14/11, Lordship.
okay, 14.
19 and 20.
May it please, your lordship. Your lordship, I beg to mention item number 14. We have informed the other side, your lordship. Matter may be adjourned, your lordship. Short date
You are paying for
for appellant, your lordship.
your good name?
As Diffusa, your lordship. The arguing council is out of station, actually, your lordship.
Okay, on request made by Mr. S. Tifusal, London Council for the petitioner. When do you want?
26th of this month.
It's the matter for this.
Highly obliged.
May I please, your lordship? Lordship, with the consent of the other side, I beg to mention item number 13.
Ah,
Lordship, as senior counsel is out of station,
who's the senior?
Lordship, M. Saranya.
Hmm.
Kindly,
You want?
Lordship, after vacation,
Okay, on request made on behalf of Mr. Saranya, London Council for the petitioner. Please after the Puja vacation.
Highly obliged.
May it please your lordship, I beg to mention about item number 17 and 18. The thing is that the matter relates to Borkhetri College, your lordship.
Okay, 17 and 18, you take note. Please this case before any other bench without one of us. Justice, you can. Huh? This is what is yes.
Item 1 of daily admission.
my lord, this matter may kindly taken after some time, my lord. After some time, my lord, my senior will be here, my lord.
We'll admit it.
My lord,
It's
we
admitted.
have some urgency, my lord. It's time bound, my lord, project, my lord. Already, we have to submit the audit report by September, my lord.
My. It was not also encountered. And this motion.
2 months, yes.
It would be done, my lord.
No, it was in the portal. In the portal was what was
16 lakhs, then how the main issue that has been raised here.
You want it after some time.
Yes, my lord.
Today, my lord.
Obliged. Obliged.
9 and 10 hearing.
May I please your lordships? Lordship, kindly the matter may be passed over for timing, your lordships.
This is the second last matter.
Lordship, only few minutes may be granted, your lordships.
Who is appearing?
My senior is MS N Haveli, your lordship.
Mr. KL is also not here.
KL also is not there. Will you sit some other day? But on whose request we are going to list?
We are agreeing for appellate petition.
Respondent, your lordship.
On request made by Mr.
SK Shah,
S. Sharma.
SK Shah, lordship.
S.K.
Shah.
Shah. Was appearing for the response. List after 1 week.
12. Item 12,
Worship may pass over the matter for the time being. My senior is on list.
This is the last matter.
Worship, he is just coming for. He's actually.
KL, you are appearing?
I am appearing for the appellant lordship.
No,
On
no,
59/2021, substantial question of law was framed.
no, 12, item 12. We are on item 12.
12, yes, lordship.
You are appearing in 12?
Yes, lordship, I am for appellant lordship.
Okay, your name is not reflected, that's why.
Yes, lordship, only B. Sharma was appearing earlier.
Okay. You are appearing for?
For
Respond.
GN, on behalf of GN Sahiwala,
Where's
respondent.
Sahiwala?
He was here.
He was here, he's just coming.
Lordship, he want to ask for framing some substantial question, extra substantial question of law with regard to limitation of the appeal.
Another substantial question law is required, my lord. I have gone through it.
Required.
So, my lord, whether the demand notice is barred by limitation, my lord.
When was the substantial question of law framed?
On 59/2021.
Long back, my lord. Now, when the hearing come, my lord, we well, another case, the issue was there, my lord. Just. This issue was, my lord, framed in another case. The same.
Why was this not raised in the,
My lord,
when the?
I'm sorry, my lord, that at the time, my lord,
And lordship, I have gone through the pleadings, but this was never raised before any of the authority.
I'm not raised, but I find, my lord, that this is necessary, my lord. This is not required, my lord. Here, it should be slightly different. The demand, my lord, not system. Demand of the central election authorities. Of my lord.
Why was this, why is this order relevant?
My lord, well, that is another matter of the same party, my lord. Their tribunal has considered that aspect, but here, without that also, the point is there, my lord.
See,
Because here, considering the extended period of limitation, whether that can be considered in the facts of the case. My lord, that is necessary.
Is that an issue in this?
My lord, no, in that order, it was the issue, but in this case, my lord, the substantial question of law, my lord, only two has been framed.
No,
And so another is to be framed, my lord.
no. Was that delay an issue in this order of Commissioner Northeastern Cable?
Yes,
See, appeal number 6 of 20.
6 was allowed, my lord, dismissed, my lord.
No. Was that an issue? Delay was an issue.
Yes,
here.
yes.
In that case, it was an issue.
Issue was
But here in my submission, lordship, this is not an issue here in this appeal. Because that was on
Was
different,
marked by limitation.
that was only on different facts and circumstances of the case. Here, this is entirely different. Here, question is that whether service tax can be levied on the subcontractor.
Then Sahiwala, what, he is now objecting.
My lord,
He's
no,
now
my lord,
objecting.
my lord, what happened? They have in the, if you also see at page 22 of the demand notice, my lord, there, my lord, they have taken extended period of limitation, whether that can be taken or not. My lord, that is very
See,
important.
issue is,
Yes.
he's objecting to your prayer. So why not you make an application after that, we'll hear it. And then if necessary, we'll frame it.
Yes, lordship,
That will be better.
because lordship, during the execution order.
No.
Lordship,
I understand that you are objecting to the prayer.
Lordship,
So let him make an application, then
Lordship,
if you have any
yes,
objection, we can
that
hear
will,
it. And then-
that will be better. Lordship.
So we are not saying anything here. We're just saying on your request, we'll list it after 1 week.
After vacation, my lord.
Provide your lordship, section 35G.
That's right, James, I want, senior counsel. For the respondent,
Yes.
this up to the puja vacation. Meantime, we file your application. That's it. Chowdhury?
Yes, my lord. I'm sorry, my lord, I was in. Yeah. Wait, please, Your Lordship. My lord, factually, I'll have to take your lordships first. If your lordships would kindly come to page number 115. Sorry, 116, my lord. Now, everything depends upon, my lord, this clause 12. Consultancy fee. Consultancy fee. Minimum consultancy fees for the entire assignment, excluding reimbursable cost, will be 16 lakhs, excluding taxes. So, my lord, we cannot quote a price below 16 lakhs. Because if we quote below 16 lakhs, then my bid would be disqualified. Now, my lord, why this expression entire assignment has been used? Now, for that, if your lordship would kindly come to page 48. If your lordship would kindly come to the scope of the work column, audit report, review of financial statements, and financial reporting framework. So this is the scope of work, my lord. If your lordships will kindly come to add-ons, towards the middle, my lord. Post financial audit support, yes. That is why the word is, my lord, entire assignment. So this is an add-on. Now please come to the last column. Additional requirements, heading, my lord, last column. Number of months for which post-audit support is required, 3 months. So the scope of the work is audit report, review of financial statement, financial reporting framework, and, my lord, audit support for 3 months. Am I clear, my lord? Now what had happened, what I did, my lord, when I wanted to offer my price, then, my lord, 2 columns was coming.
In the portal.
Yes. And when I get 0, then it was not accepting. So what I did for this additional add-on,
What was the other column?
other main column was for price bid and 2 column. Then for the first column, for the second column, I wanted to just quote something. But when I gave 0, my lord, it was not coming. That position I have explained, my lord. If your lordship would kindly come to page 227. Actually, these are too highly technical, my lord. And I am a person who is not very savvy with all this, to be honest. So, now this is what happened when I wanted to post my financial rate. Reply. In response to your query, we would like to mention that as per your white tender dated 25/1/24, the minimum consultancy fee prescribed was 16 lakhs, excluding taxes at point number 12 of page 67 in the RPF document, which was made available in the GM portal. And nowhere in the RPFP it was mentioned that post-audit support fee was required to be quoted. Accordingly, we had quoted consultancy fee of 16 lakhs plus 18% GST in our financial bid. However, when the same was uploaded in the GM portal, it was required to bifurcate fee into consulting fee and post-audit support fee. Further, post-audit support fee column did not accept 0 amount, and therefore we had to bifurcate the fee into consulting fee and put a nominal amount in post-audit fee column, assuming post-audit support fee as the total assignment. So I just gave 3 rupees for this additional assignment, and my lord, 15 lakhs 99,997 I quoted for the other one. Now, what they initially did, my lord, they accepted my tender and they adjust me as L1. Please come to, my lord, page number 221. Hmm. 221, bro. Sorry, 224. I'm sorry, my lord. Page 224. Kindly see, my lord. This is these offer prices in bid and not approve except a price. This may change if buyer resorts to so and so. Now kindly see Rama K. Gupta and Company L1. 18 lakhs, 88,000 including GST. So I was at just L1. Then, my lord, at page 226, the buyer requires clarification from you in order to determine financial viability of your offer. The buyer has requested a price justification for 15 June 24 against GM. The request can be viewed in sellers panels and a participated bid section. You must respond and submit your clarification as requested by buyer by so and so. Submit your response as soon as possible, as the buyer will proceed with determining the financial suitability after due date. So this is how, my lord, the clarification was sought. And page 227 was my reply, which I have already laid. Then at page 230, my lord, I was disqualified. Kindly see on top, Rama K. Gupta, last column, rank disqualified. Now, my lord will kindly come to page number 319. Now, please come to 319, my lord. Rama K. Gupta disqualified. The bidder have quoted 18 lakhs 87,997 with taxes in audit fee, which is rupees 3, lesser than the minimum prescribed audit fee of 18 lakhs 88,000. The price justification detail was sought from the bidder on so and so, and reply submitted by the bidder was not accepted on the ground of quoting lesser price in the minimum prescribed fee part as per decision taken by the technical and evaluation committee on so and so. Then, my lord will kindly come to page 322. This is the minutes. The meeting of the technical and evaluation committee was held on 26th of June in the office of the state mission director to examine the financial proposal of the 4 bidders who qualified in the technical evaluation stage. The committee have examined the financial proposal of 4 firms, namely Rama K. Gupta and others. After detailed scrutiny of the financial proposal of 4 bidders, it was found that the firm named Rama K. Gupta and Company as L1 in GM portal have quoted 18 lakhs 87,997 with taxes, which is less than the minimum prescribed audit fee of 18 lakhs and 88,000 with taxes as mentioned in RPF. In view above, technical and evaluation committee have decided to reject the financial proposal of the Rama K. Gupta, that is the appellant. Now, my lord, what the mischief they have done, please come to me, lord, page 305. before, my lord, on 5th of February 2024, there was a pre-bid meeting. Now kindly see, my lord, point number 12, consultancy fee. The bidder sought clarification on minimum fee payable for the audit assignment. It is clarified that minimum prescribed audit fee is rupees so and post-audit fee will be payable for providing post-audit fee for 3 months as mentioned in the bid document. Bidders have to quote both for audit fee not below the minimum prescribed fee and post-audit fee support in the GM portal. My lord, kindly see on the date uploaded on 18/7/24. My lord, if your lordship kindly takes this document to logical end, this officer will have to go to jail, my lord.
Uploaded.
On right hand side, my lord, handwritten part is there.
Computer will not know.
Huh.
Last date was.
Uploaded on their website. 18/7/24. As the now, my lord, kindly see for this, what does the tender document say?
Was the last date for submission?
Last date to kiman asile? 1 second, my lord. I'm giving the date. Date to there.
Page 45. 20/02/2024.
Twenty 22/24. Now, my lord will kindly come to page 68. Supposing, my lord, a bidder wants some clarification. This oral business will not do. It's an e-tender, my lord. Please come to page 68. 13. Clarification and amendment of RFP. The e-procurement system specified in ITC 17.1 provides for online clarification. The consultant may request an online clarification of any part of the RFP during the period indicated in the data sheet before the proposal submission deadline. That means before 22. Clarification requested through any other mode shall not be considered by the client. The client will respond online by uploading the response for information of all solicited consultant. Should the client deem it necessary to amend the RFP as a result of clarification, it shall do so following the procedure prescribed below. So first of all, my lord, any participating bidder before the last date of submission of bid will have to upload the query online, not otherwise. Now let them show where is that query. In fact, my lord, there was a pre-bid meeting where nobody has discussed this issue because this issue cropped up only on the date when we went to upload our financial offer. Prior, because there is no specification in the tender as such. Only when we wanted to give our financial offer, this issue cropped up. Now, my lord, kindly see how they are trying to cover up. The pre-bid meeting took place on 5th of February. They upload something on 18/7/24. Now let them show that any bidder has made that query. And where is if there is a pre-bid meeting, where are the attendants? End of the day, my lord, to achieve transparency only this procedures has been introduced, not to circumvent. And my lord, on 12/7/24, there was an interim order. Thereafter, they have done it. So, my lord, 305 is a serious matter, my lord. I don't think they should have resorted to this. Once they have adjusted me as the L1, then they do all these things. So, therefore, my lord, And on last occasion, my lord, my learned friend was directed to produce the records.
Created on 17/7. PB meeting 5th February, একদম পুরা কম্পিউটার অপরা হলো, ইন্টারনেট অপরা হলো, ক্রিয়েটেড on. একটু যাতে আর বেশি প্রোগ্রাম নাই। পেমেন্ট এলে কত যাব না আমার পেমেন্ট
আলবাল দেখাই দিতে এখন এখানে এগুলো কি যায়
5 তারিখে মিটিং হয়েছিল হাসান আপলোড করতে পারি ক্রিয়েটেড
এটা কি দেখা এটা কি
Mr. Chaudhary,
Yes, my lord.
this in the judgment at para 9,
Yes, my lord.
page 311.
Yes, my lord. As can be seen from the amendments made by the learned counsel for parties and pleadings on record, the minimum prescribed bid for the consultancy assignment was to be 16 lakhs. Due to default in GM portal, the petitioner could not submit his bid in one part. He submitted his bid of 16 lakhs minus 3 for the entire assignment on one part, while submitting 3 as his bid for the post-audit service fee. Same was done due to bifurcation of the bid amount in GM portal, as the bid could not be submitted in one part only. However, pre-bid meeting, this is the thing below.
That's why. That's why. That's
Ah, this is the issue.
My lord. Everything boils down to this 5 to 20.
Yes.
Yes, my lord. So Chaudhary has pointed out that some handwritten note, you had uploaded it. Yes, yes, my lord. What has come? Was uploaded. Whereas the last day of submission of bids was page 45, supply me.
uploaded
Now,
on 17.
কি content করবে?
this 5 to 2020. How did you establish?
That is totally false, my lord. It was uploaded on the time itself, my lord. Yes, his record is showing, my lord. Because that handwriting part is not in the record.
No, here you have said that the petitioner's representative attended the.
Yes, yes, his sign is also there.
Well, how do you prove it?
Yes, yeah, his sign is there in attendance sheet.
So 2 things. One, Mr. Chaudhary attended or his client attended.
Yes.
One. Yes. Two.
Before
the last date of submission of bids, this clarification was uploaded in the website, GM website.
Not GM, my lord, because
Wherever,
yes,
wherever
in
it
our website, my lord.
Wherever the thing has to be uploaded in terms of the tender, it was uploaded.
Yes.
Can you show that?
My lord, that is uploaded. That is why, my lord, the others, my lord, they have correctly submitted their bids.
No, I don't.
Only the petitioner wrongly submitted.
Do you have the portal page, some copy of that? portal? How-
We have checked, my lord. In the portal page, there was no date when we uploaded, my lord. That is totally factual dispute, my
My
lord.
lord, these officers should be hauled up, my lord. These officers, no, my lord, lordship will take this matter very seriously. There, because the other day I made a submission that because taking advantage of the restraint your lordship's exercise, they're taking advantage. Kindly see me, lord. He has been wrongly briefed. Yes. Kindly see, it was uploaded on 17/7, my lord. Nothing is there. I was waiting for this only. I didn't refer to it initially, my lord. And see, created on 17/7.
Modified 17/7.
My lord, somebody has to say, we want a clarification and it must be online. Any verbal request, I mean, hard copy request will not be accepted. That clause 13.
Filed an affidavit before the last signal.
No, my lord.
That's fine.
At the motion stage. Motion stage. So,
Record was there, my lord. I produced the record on the day actually.
affidavit file kora nai. Affidavit was not filed.
As the urgency was there, my lord. Court, after going to the record, Honorable Single Judge disposed of the matter, my lord.
What we find here is another thing that was satisfied with your conception by relying on 5 to 20.
Yes.
Because, yes,
Then-
yes.
Then he went into the clause 30,
30, 31, 30. Yes, yes.
Then that Mr. Chaudhary will have no grievance because now that has already been, process is directed to be taken.
My lord.
But this 5/2/2024.
My lord, one more thing.
Either you must have to say that without that clarification also.
Yes,
Mr.
my lord.
Chaudhary was to do 16 plus.
Yes, my lord. That is why. I want to submit, Lordship may kindly.
Before that, if your lordship should kindly come to 309, what my learned friend submitted on that day. 309, my lord. As Dr. Learned Counsel for the respondent 1 and 2 submits, page 309, my lord. As Dr. Learned Counsel for respondent 1 and 2 submits that petitioner has misunderstood the NIT clause, he submits that though bidders were to submit their bid amounts in one part of the entire assignment, a default was created by GM portal by which bidders were also required to submit post-audit charges. He, however, submits that say this was clarified in a pre-bid meeting held on so-and-so, wherein a representative of the petitioner had also participated. My lord, yes, there was a pre-bid meeting, we participated. And I put my signature, but this issue was never discussed because this issue did not crop up, my lord. We never knew. It was only on 12th when I wanted to offer my financial with that this default was shown in the system. Now, what is the occasion on 5/2 to go for that? How do we know, my lord, on 12th there will be a default in the thing? Then, my lord, I'll ask. And I never did. And in any case, in terms of page 68, para clause 13, that somebody has to upload that request. Which is that?
These bids are uploaded together or in different points of time?
No, my
Financial
lord.
bids
Suppose
together,
everything,
together
anything, my
is
lord,
5/2.
including submission of bid has to be online.
5/2
Yes,
together, yes.
5/2. On 5/2, there was a pre-bid meeting, but other issues were discussed. That statement we have made in the writ petition.
Mr. Chaudhary,
My lord.
this point is disputed. Clearer than this. You have raised a very pertinent question that this was uploaded only on 17.
System itself so.
July. I think we must ask them to file a short affidavit on that point.
That I will file, my lord. But before that, whether that is required or not.
No, that is not the, see, this is a writ appellate.
My
We
lord.
go by what is there before the single judge.
My lord.
I also had that.
My lord,
We were discussing that, my lord, and I was discussing that why was this point not included? It is 16 plus add-on will come subsequently.
That I will
We can
satisfy.
have a different charge altogether.
That point I will
But you
satisfy.
have now projected the case before the honorable single judge, that because of this clarification, we have done it. So you will have to bring it on record.
My lord, they are disputing the upload, my lord.
Leader does.
Only upload,
Leader
not.
does. Whatever documents are there. Find an
Yes,
No, there are two issues. On 5/2/2024, this issue was not discussed. That
Yes.
is one point taken by the
That is
appellate.
factual aspect.
Oh.
Yes, my lord.
And the second
Because as
thing
per
is
my
that
record, this is discussed.
the clarification that was done in the 5/2/2024 repeat meeting was uploaded only on
7.
17/7/2024.
Yes. Before that, can I have?
Yes, yes,
So
yes,
my
yes.
case, my lord.
The one. Mr. Chaudhary, very
Hello.
provision with regard to financial bid in the NIT.
One second, my lord. No, my lord, clause 12 only. Huh? How to realize how to nine? One second, my lord. Clause 12 is only, no? Summary of cost. My lord, there is sub-classification, but end of the day, it is clause 12, which is determinative.
Other than this, there is nothing.
Nothing, my lord.
What about the add-on? Any specification with regard to the add-on? Because this is with regard to the main work.
Yes.
What is it?
Add-on to 48. Page 48, my lord. Add-ons, post-financial audit support, yes. So number of months for which post-audit support required is 3 months. Is এইটোতো টু পেকেট, এটাতো টেকনিকেল, এটা my lord, somebody is showing when we have not participated. It's a very serious matter. Let them file an affidavit. First, one, that my lord, there was a request from any of the bidder online. And two, they have taken this decision.
Where is your point here in the?
Yes, yes, yes. Ground to Kurjur,
grounds. So on that, and the charge sheet was not approved by the, my lord, disciplinary authority. These are the primary grounds. And on the same facts, my lord, exactly similar facts, here is a case of a judicial officer of the Rajasthan. There, my lord, on the same grounds, the writ petition, my lord, division bench has set aside the decision of the, my lord, High Court itself, food court decision. Now, your lordship may come to the paragraph 2, my lord. The brief facts of the case, as I'm not reading entire, my lord, I'm just giving 2, 3, 4, 5 paragraphs. The brief facts of the case as pleaded in the writ petition are: the petitioner, who was working as assistant district and session judge, was in receipt of a memorandum dated so and so, served under Rule 16 of the Rajasthan Civil Service Rules. And my lord, the allegation was that, my lord, the petitioner arbitrarily awarded comparatively higher and lesser compensation in, my lord, motor accidents. That was the, my lord, allegation. And the facts are that your lordship may come to paragraph 3. The petitioner has pleaded that prior to issuance of the charge sheet, the respondent High Court conducted preliminary inquiry and recorded the statement, and copy of the preliminary inquiry report was not given to the petitioner. These are the contentions, my lord. Then your lordship may kindly come to paragraph 31 at page 7. I'm just giving the gist, my lord. Learned counsel appearing for the petitioner so-and-so has made the following submissions. Number 1, the charge sheet dated 5/7/2012 has been issued by the Registrar of Vigilance, who is an incompetent authority. Then your lordship may come to, my lord, Roman 3. The enquiry officer was appointed even before the receipt of the reply by the petitioner, and the same has been in violation of the rules. Then, my lord, as against that, the contention of the High Court was, my lord, at page 9, Roman 8. Roman 7 and 8, my lord, page 8.
Para 32.
Para 32, my lord. I am reading, my lord, Roman 7. The petitioner was not, this is the stand of the High Court. The petitioner was not prejudiced in any manner in the entire departmental inquiry as per Rule 32 of the High Court rules. Even if there has been some omission in the procedure, the same would not invalidate the disciplinary proceedings. The scope of judicial review is limited under Article 226 of the Constitution of India, and until findings of the inquiry officer are perverse and without considering the relevant material, the same cannot be substituted. Then, my lord, Roman 8, the allegation of the petitioner that before filing reply to the charge sheet, the inquiry officers are appointed would not result into any violation of principle of natural justice, since the petitioner has submitted her reply denying the charges, and once regular inquiry is conducted, no delinquent officer can be allowed to raise a plea that the disciplinary authority has to wait for getting the reply, and only thereafter inquiry officer can be appointed. So, my lord, this contention has been rejected by the division bench. Now, my lord, the findings of the division bench. Your lordship may come to paragraph 53 at page 22.
Page?
Page 22.
22.
Madam. I am pressing this case because my lord, facts are almost identical.
Yes.
Paragraph 53. This court finds that the apex court in the case of Sunny Abraham versus Union of India has also dealt with the issue of ex post facto approval by the disciplinary authority, and found that the charge sheet, charge memo, if not having approved of the disciplinary authority, would be non-est in the eye of law. Then, my lord, the judgment of the Honorable Supreme Court has been quoted.
Here in your case, you are saying it was not placed before the executive council.
It was not at all placed, my lord. Then your lordship may kindly come to paragraph 60 and 62. I'm reading paragraph 60 at page 25. The very purpose of providing an opportunity to a delinquent after receipt of charge sheet necessarily gives him a right to defend himself, that is, either to deny the charge or to admit the charge. The disciplinary authority can make up its mind of appointing inquiry officer only in the eventuality of charges not being admitted, and as a necessary corollary, the disciplinary authority at the time of issuing charge sheet cannot appoint inquiry officer simultaneously. Otherwise, there would be no purpose of seeking written statement reply of the delinquent, and it would reflect the predetermination of the disciplinary authority to conduct the disciplinary proceeding. The principles of natural justice also require that delinquent has to be given a fair opportunity to defend himself, and if charges are not admitted, the regular departmental inquiry is conducted. Then, on the basis of findings recorded against the delinquent officer, the disciplinary authority has ample power to punish a guilty officer. Then paragraph 62 is important. The facts of the case at hand shows that at the time of issuing charge sheet to the petitioner, the decision was also taken to appoint an inquiry officer, that is the register vigilance, at the relevant time, and later on inquiry judge, and as such, the procedure adopted by the respondent High Court cannot be considered valid according to rules of law. And accordingly, my lord. So our, my lord, the appointment of the inquiry officer was prior to, my lord, framing of the charge sheet, and the, my lord, charge sheet was also not approved by the authority. So on this point, my lord, since the facts are similar, I'm just sending this.
Okay, heard Mr. M.K. Chaudhary in the training calls. Assisted by Mr. T. Chakravarti, senior counsel for the petitioner. On request made by Mr. P.G. Fugan, standing counsel Guwahati University. When do you want?
My lord, after 2 weeks, my lord.
My lord, bringing the records from, my lord, university does not take 2 weeks time.
My lord, our argument will be revolving around that offer letter and appointment letter.
Okay.
My lord, so, my lord, records could be very vitally important.
Yes, but how long does it take to
Part
come
of
to
the records
records,
are
my
with
lord?
me, my lord.
List the matter on 26th. 26th.
26. My lord.
That's the Thursday hearing day.
As a last.
It is made clear there shall be no adjournment on any grounds on the next day.
Highly blessed.
Most of
2 and 3.
Oh.
Wait, please, Lord. Just to recapitulate, my lord, what has transpired so far, I'll just recall those factual, my lord, brief points. My lord, on 17/4/2012, my lord, an advertisement was issued for the LDA, for the post of LDA. And I applied in that post, my lord, and pursuant to a valid selection process, my lord, I was appointed as an LDA. And I was appointed, my lord, on 21/2016, my lord. If your lordship kindly turns to page 23 for a moment, my lord. Page 23.
1 minute.
My lord.
You appointed us
LDA, my lord. Page number 23, my lord. 21/2016 is the office order, my lord. 21/2016, my lord. May I just read out the order?
Yes.
With reference to their applications for the post of LDA and as per the recommendations of the selection committee in its meeting held on 4/1/2016 and subsequent approval of the Honorable Vice Chancellor on 5/1/2016, the following candidates are engaged as LDA in the office place as shown against their names as given below. And serial number 3, your lordship will kindly note my name, my lord, Sosanko Soikia, serial number 3. Place of engagement is Secretary Office, my lord. Now, if your lordship kindly turns to the next page, page 24, clause number 5, my lord. they say the engaged candidate shall have to follow the service conduct rules applicable for university employees. So there is no dispute with the fact that the, my lord, service conduct rules of the Guwahati University apply in the present case, my lord. Now thereafter, my lord, my services were regularized from, I mean, extended from time to time. And since the services was not regularized, we were constrained to file a writ petition praying for regularization with some other employees. And on 25/9/2021, my lord, what had happened? 25/9/2021, my lord, I was arrested. And on the same day, my lord, on the very same day, the respondent number 2, that is the registrar of the Guwahati University, issued the impugn notification by way of which I was terminated. Now that impugn notification, my lord, will find at page number 38, my lord. Page number 38.
You were arrested on?
On the same date, my lord, 25/9/2021, I was arrested. On the same date, they issued this notification.
25/9/2021,
my lord. Page number 38, my lord.
Yes.
Now, page number 38, your lordship will see, my lord, notification. This is notified for information of all concerned that the Chief Minister's Special Vigilance Cell has arrested number 1, Sosanko Soikia LDA, Office of the Secretary. Number 2 and number 3, there are 2 other persons in connection with APDCL recruitment test. And second paragraph, in view of the above, in view of my arrest, the service of Sosanko Soikia LDA has been terminated with immediate effect as per clause 1 of the terms and condition of the appointment order dated 21/2016. So at the time of issuance of the impugned order, the reason attributed for my dismissal was my arrest. If your lordship kindly sees, my lord, page 38. If your lordship kindly sees page number 38 for one moment, the second paragraph, it says, in view of the above. In view of the above means I was arrested, and on the basis of my arrest, due to my arrest, they have terminated me. At the time of issuing this impugned order, that is the reason recorded. No other reason, my lord. This is the only reason. And my lord, we'll see, my lord, at the bottom, moreover, the second last paragraph, moreover, the entry of the above 3 persons is restricted inside GU campus. This is the, my lord, extent of stigma which has been attributed to me without even giving me a, my lord, fair opportunity of hearing. An extremely stigmatic order was issued, my lord, on 25/9/2021, and in that, my lord, in that order itself, they have recorded the reason of my termination, and the reason of my termination has been stated to be my arrest by the Chief Minister's Special Vigilance Cell. Now, my lord, they don't even serve me this notification copy, my lord. My entry into the Guwahati University has been barred, my lord. Running after pillar to post, my lord, after running from pillar to post, I could somehow gather this copy. I immediately approached this honorable court, and your lordship had protected me by staying this order, my lord. It's a different matter that they have not complied with the interim order till date, but your lordship had protected me. In fact, there's a, my lord, interim order which was passed, my lord, on 30/6/2022. Now, my lord, 30/6/2022, your lordship had stayed this order of termination. 28/7/2022, the Guwahati University filed their affidavit. There's an affidavit which has been filed by the Guwahati University on 28/7/2022. 28/7/2022, my lord, it contains 27 pages. The affidavit which filed by the Guwahati University, 28/7/2022, they filed this affidavit. 28/7/2022, my lord. It has been filed by one Dr. Hemanto Kumar Nath.
Yes.
My lord. Now, this affidavit consists of 27 pages. In this 27 pages, my lord, they've not made even a single whisper to the effect that the inquiry which was supposed to be held against me was dispensed with. So till 28/7/2022, the stand of the Guwahati University was different. Till 28/7/2022, my lord, they were beating around the bush. That is a different matter. But then they had never stated in this. This contains, my lord. There is a total of, my lord, 7 paragraphs. This affidavit has 7 paragraphs and 27 pages. And in the entire affidavit in opposition, your lordship will not find a single whisper to the effect that the inquiry against the petitioner was dispensed with, my lord. Now, my lord, on 28/7/2022, they filed their affidavit. Now, the next important date is, my lord, 25/7/2023. On 25/7/2023, my lord, my services were regularized, which your lordship will find at page number 96, my lord. Page number 96, running page. In fact, the judgment starts from, my lord, page number 92. Running page, my lord, page number 92, my lord.
Yes.
WPC number 4271 of 2018, my lord. And serial number 3, my lord, my name is there, Sosanko Soikia. And relevant portion, your lordship will see page number 96. Page number 96, my lord, date of judgment is there, my lord, 25/7/2023. And page number 101 is what concerns us, paragraph 12. Paragraph 12, 6th line from the bottom, my lord. Paragraph 12, 6th line from the bottom. Your lordship will see the line starting from although Mr. Fukon has submitted. Has your lordship got it, my lord? Paragraph 12, 6th line from bottom.
Yes.
Although Mr. Fukon has submitted that the services of the petitioner number 3 in WPC number 4271 of 2018, VIZ Shri Sosanko Soikia has been terminated on the ground of committing misconduct. This court is not concerned with the said aspect of the matter in the present proceeding, since the order of termination has reportedly been assailed by him in another writ petition which is pending before this court. And, my lord, the operative portion, your lordship will kindly turn, my lord, to page number 104. This is where the operative portion lies. Page number 104, paragraph 19, my lord. Paragraph 19. For the reasons stated herein above, this court is of the opinion that all the writ petitions must succeed and are hereby allowed. The writ petitions are therefore disposed of with a direction upon the respondents, more particularly the registrar, to process the cases of the petitioner in light of the observation made herein above, and thereafter take necessary steps for regulation and regularization of the services of all the petitioners by issuing the necessary orders. So my services was directed to be regularized by this honorable court. They did not do this also, my lord. Now, my lord.
So you've still not been regularized?
I have not been regularized. I have not been allowed to join duty despite the honorable court staying the impugn notification, my lord. They don't, my lord, they are not even showing scant respect to the orders of this honorable court. Multiple orders have been passed to give me relief, but they are negating that relief, my lord. Now, my lord, I was regularized. My services were there. On 27/2/2024, my lord, hearing commenced in this matter, which your lordship will find, my lord, at page number 124. Page 124, my lord. On 20, your lordship will see 27/2/2024, hearing of this matter commenced. Once, my lord, the hearing started, the authorities took a complete U-turn. Because the earlier affidavit which was filed, my lord, on 27/8/2022, they never mentioned about dispensing with the inquiry. But once the hearing started, they realized that they perhaps don't have a good case. To somehow justify, a new ground was, my lord, manufactured to the effect that the inquiry which was supposed to be held against me was dispensed with reasons to be recorded in writing. I had, my lord, made multiple pleas before this honorable court to give me access to the records. For some reason, my lord, which is beyond my understanding. They have not shown me the records. I mean, they have not given me full access to the records. So therefore, if this honorable court said, okay, if you don't show the records, at least you give the reasons as to why you want to dispense with the inquiry. And those reasons, my lord, will find at page number 109. So by way of an affidavit, my lord, they want to improve upon the records. Page 109, if your lordship kindly sees the last paragraph, page 109. Page 109, my lord.
Yes.
The last paragraph. In such situation, it is required that such employee who happens to be engaged by Guwahati University be immediately suspended and charge sheet is to be served upon him to start the disciplinary proceedings. Till this line, everything was okay. However, your lordship will kindly mark this portion. However, this is not feasible to be done as he is presently in police custody. And the relevant records to be verified for the purpose of disciplinary proceeding could no longer be accessible to the university. So they say that the records can no longer be accessible to the university, although the records were always with them. Today also the records are before your lordship. It is the university authorities who have provided the records. But to justify, they say the records are not accessible to them. Although the records were always in their custody, my lord. Further, it is clear, now this your lordship will kindly mark. Further, it is clear that the said DP will be lengthy and a time-consuming one. Given the voluminous documents to be checked, while his engagement is only up to 31/12/2021, under the circumstances and the given situation, it is well nigh impossible or not feasible to start an inquiry. Because they will have to check the documents. It is a time-consuming one. So they don't want to apply their brain. Assuming that this ground which they've undertaken now is not a manufactured fresh ground. And my lord, I have filed a reply to that effect, which your lordship will find at page number 119. I have dealt with, my lord, both the grounds. These are the two basic, reasons as to why they thought, my lord, the inquiry against me should be dispensed with. My lord, firstly, page number 119, my lord. Firstly, the records which was recorded, the reasons. Firstly, that it is not feasible to initiate disciplinary proceeding against the petitioner as he was in the police custody and the relevant records to be verified for the purpose of this could not be accessed by the university. In this connection, the petitioner humbly begs to state that the purported reason as recorded above is insufficient, irrelevant, improper, as well as inadequate. If the petitioner was in police custody, the authorities ought to have waited for his release by suspending him. Normally under this, because the service rules, my lord, if your lordship kindly has the service rules, your lordship has the service rules, my lord. If your lordship kindly takes up the service rule, service rule. I have given a copy, my lord, service rules.
Yeah. Conduct and appeal rules.
My lord, my lord. Guwahati University Employees Service Conditions, Conduct and Appeal Rules, 1970. Internal page 12, rule 26, my lord. Internal page 12 at the bottom, rule 26. Now, rule 26 provides for dismissal, removal, and suspension. That is what they normally do, my lord. If somebody is arrested, they suspend him. Rule 26 provides for suspension. So they ought to have, my lord, waited till I am released. They should have suspended me, but they dispensed. Purportedly, if these reasons are actually there, then they should have suspended me. Now, if your lordship, if I may continue, page number, my lord, 119, page number running page 119, that is the two grounds they have taken, and I have replied to those two grounds. I'll just continue from where I left, my lord. Page 119, second paragraph. If the petitioner was in police custody, the authorities ought to have waited for his release by suspending him under the relevant rules. The questions of relevant records not being accessible to the authorities does not arise, as the said records were always in the custody of the authorities in Guwahati University campus. It is me who have been debarred from the campus. So these records are always with them. These records are there today before your lordships also. And my lord, the second purported ground, if your lordship will kindly note the second paragraph. Secondly, another purported reason so recorded in the note dated, these are purported reasons, is that DP will be lengthy and time consuming, given the voluminous documents to be checked while his engagement is valid only up to 31/12/2021. In this connection, the petitioner humbly begs to state that merely because DP might be lengthy or time consuming, and the documents which needed to be checked are voluminous, the authorities could not have dispensed with the inquiry, more particularly when a lifelong stigmatic remark has been made against the petitioner, my lord. So these are the two reasons, and these are the, I have placed before your lordship, my lord, those are neither cogent nor relevant nor adequate. Now, my lord, some case laws I would like to place. Now, my lord, till 27 to 2024, that is the day on which the hearing commenced, we had, my lord, part hearings. I was arguing on Article 14, 16, 311, 2. Suddenly, my lord, once they realized that this is not a, my lord, perhaps a good case for them, they manufactured a fresh ground. Now the entire, my lord, argument is restricted as to whether in the facts and circumstances of the present case, an article under 311(2) could have been dispensed with by the authorities, my lord. Just to that effect. Because now, my lord, the entire compass has narrowed down. Now I need not go to all those, my lord, whether it is stigmatic, unstigmatic or not. Only 311(2), my lord. 311(2)(b) rather. Mohinder Singh likhon diya. Only one paragraph. Your lordship knows Mohinder Singh Gill. Just one paragraph, paragraph 8. Paragraph 8, my lord. My lord. Paragraph 8, my lord. The second equally relevant matter is that when a statutory functionary makes an order based on certain grounds, its validity must be judged by the reasons so mentioned and cannot be supplemented by fresh reasons in shape of affidavit or otherwise. Otherwise, an order bad in the beginning may, by the time it comes to the court on account of a challenge, gets validated by additional grounds later brought in. This is exactly what has happened in this case, my lord. If I may just take your lordship to one page, in fact, that page of termination, my lord, impugn order, just one page. That is, my lord, page number 38. Now, in page number 38, my lord, your lordship will see what was the reason assigned at the time of, my lord, second paragraph. The first paragraph states that I was arrested by CM Vigilance Scale. And second paragraph, my lord, your lordship will see the starting of second paragraph in view of the above. So the reason for my dismissal at the time of the issuance of the impugn notification was my arrest. These grounds were never there. At the time of issuance of the impugned order, the reason was that in view of the above, and the view of the above means that I was arrested and therefore I was terminated. Now they are seeking to supplement fresh reasons to somehow justify, my lord, the issuance of an extremely stigmatic my lord, order. And secondly, my lord will kindly, my lord, see, Jaswant Singh. Okay. I'll not trouble your lordship with the entire judgment, just two paragraphs. Assuming, my lord, assuming that these additional grounds have not been freshly manufactured, assuming, even then also, this cannot withstand the, my lord, eyes of law. AIR 1991 SC 385, Jaswant Singh, paragraph 8, my lord. Paragraph 8. May I just read paragraph 8, my lord?
Yes.
Paragraph 8, my lord. This is no more than a mere reproduction of paragraph 3 of the impugn order. Our attention was not drawn to any existing material existing on the date of impugn order in support of the allegation contained in paragraph 3 thereof, that the appellant had thrown threats that he and his companions will not allow holding of any department inquiry against him, and that they could not hesitate to cause physical injury to the witness as well as the inquiry officer if any such attempt was made. Now it's very important, my lord. It was incumbent on the respondents to disclose to the court the material in existence at the date of passing of the impugn order in support of the subjective satisfaction recorded by the respondent. Number 3, in the impugn order, clause B of the second proviso of Article 311(2) can be invoked only when the authority is satisfied from the materials placed before him that it is not reasonably practicable to hold a departmental inquiry. This is clear from the following observations of at page para 270 of Tulsi Ram's case. A disciplinary authority is not expected to dispense with a disciplinary inquiry lightly or arbitrarily, or out of ulterior motives, or merely in order to avoid the holding of an inquiry, or because the department's case against the government servant is weak and must fail, which is exactly what happened in the instant case, my lord. The decision to dispense with the inquiry, the department inquiry, cannot therefore be rested solely on the ipse dixit of the concerned authority. When the satisfaction of the concerned authority is questioned in a court of law, it is incumbent on those who support the order to show that this satisfaction is based on certain objective facts and is not the outcome of the whim or caprice of the concerned officer. So when I have challenged, my lord, they have to show that these reasons, these two reasons, purported reasons, freshly manufactured ones, assuming that they were not freshly manufactured. So it has to be based on, my lord, objective facts. And my lord, I'll not trouble with the entire paragraph. Just the fifth line from the same paragraph 8, fifth line from bottom. To put it tersely, has your lordship got it, my lord? To put it tersely, the subjective satisfaction recorded in paragraph 3 of the impugn order is not fortified by any independent material to justify the dispensing with of the inquiry envisaged by Article 311(2). We are therefore of the opinion that the short ground alone, the impugn order cannot be sustained. And paragraph 10, my lord, the appeal was allowed. It cannot be, my lord, at the ipse dixit of the authorities, and they cannot take it lightly or arbitrarily. At the end of the day, my lord, they're rendering this person a stigmatic whole life. He can't even enter the campus. This is the, my lord, extent. They have gone. So therefore, they cannot take it lightly or arbitrarily, my lord. And secondly, my lord, Southern Railway. Secondly, my lord, Southern Railway Officers Association versus Union of India, 2009 9 SSC, page number 24. I'll just point out two relevant paragraphs. Paragraph 21. Paragraph 21, my lord. Paragraph 21. 2009 9 SSC 24, Southern Railway. Paragraph 21 says, my lord, indisputably, holding of an inquiry, if any misconduct is alleged on the part of delinquent official, is obligatory, wherein the delinquent employee is to be informed of the charges against him and given a reasonable opportunity of being heard in respect thereof. The second proviso appended thereto, however, makes 3 exceptions with regard to the constitutional requirement of holding an inquiry. Clause B whereof provides that in case where the disciplinary authority is satisfied that it is not reasonably practicable to hold such inquiry, subject of the course of the condition that therefore reasons are to be recorded in writing. Recording of reasons thus provides adequate protection and safeguard to the employee concerned. It is now well settled that the reasons so recorded must be, number 1, cogent, and number 2, sufficient. Satisfaction to be arrived at by the disciplinary authority for the aforementioned purpose cannot be arbitrary. It must be based on objectivity. The reasons which they have recorded in the present case, that DP will be time consuming, ultimately they will be conducting the DP. If they want, they can do it in a short manner, but they don't know. The documents will have to be verified. They'll have to verify the documents. Ultimately, it is the records are not there in the custody. Records are always there in their custody, my lord. How can the records be I was put behind the bars. The records were not put behind the bars. So these reasons which they have provided, these two reasons, my lord, they are neither, they are not based on objectivity. They are neither cogent. They are neither sufficient, and they are nothing but it reflects the that the authorities were did not apply their mind. In fact, they were their conduct shows that they were rather, my lord, vindictive against the petitioner, and therefore, my lord, these two reasons are are not, my lord, sustainable in the eyes of law. And thirdly, my lord, in fact, this case law I have produced before your lordship earlier also, Reena Rani, my lord, Reena Rani versus State of Haryana, 2012 10 SSC 215. 2012 10 SSC 215, my lord. Reena Rani, I have already provided a copy.
Reena Rani.
Reena Rani, my
Yes.
my lord. Just to place the facts before your lordship. Paragraph 3 are the facts, my lord. The appellant joined service as constable in the police department of the government of Haryana on so and so. After 3 years and 2 months, the SP passed an order and dismissed her service by invoking clause B of second proviso of 311(2), read with rule so and so of Punjab police rules. While she remained posted as prisoner escort guard from 24/5/2008 to 18/9/2008, she developed close relation with one Mustaq, son of Istaq Hussain Khan of Gorakhpur, despite the fact that he was involved in 7 criminal cases registered under section so and so. And these are the facts. Now, if your lordship kindly turns to paragraph 8, my lord. Paragraph 8, very relevant, my lord. Paragraph 8. In the order of dismissal, the superintendent of police has not disclosed any reason as to why it was not reasonably practicable to hold regular departmental inquiry. The learned additional Advocate General fairly stated that the order of dismissal does not contain the reasons as to why it was not reasonably practicable to hold regular departmental inquiry against the petitioner. Same in my case also, my lord. The reasons were something else. They never said that my inquiry was dispensed. And if your lordship kindly skips to the next paragraph, paragraph 9, in view of the above, we hold that the learned single judge and division bench of the High Court committed serious error by negating appellant's challenge toward dismissal from service without inquiry. The division bench of the High Court did not examine the issue in a correct perspective and made general observation that each case is required to be decided on its own facts and no straitjacket formula can be adopted to decide whether it is reasonable and practicable to hold regular inquiry for imposing major penalty of dismissal from service. Such general observations could not have been made basis for approving her dismissal from service. And then, my lord, this Tulsiram has been quoted. Now, just from there only, if your lordship kindly turns to the next page, my lord. Next page, para 134. This is 134, my lord. Para 134, my lord. It is obvious that the recording in writing of the reason for dispensing with the inquiry must precede the order imposing the penalty. The reason for dispensing with the inquiry need not therefore find a place in the final order. It would be usual to record the reason separately and then consider the question of the penalty to be imposed and pass the order imposing the penalty. It would, however, be better to record the reason in the final order in order to avoid the allegation that the reason was not recorded in writing before passing but was subsequently fabricated. The reason for dispensing with the inquiry need not contain detailed particulars, but the reason must not be vague or just a repetition of the language of clause B. For instance, it would be no compliance with the requirement of clause B of the disciplinary authority simply to state that he was satisfied that it was not reasonably practicable to hold an inquiry. And my lord, if your lordship kindly turns to the next paragraph, paragraph 135. I'll not trouble with the entire paragraph, my lord, just the last portion. 7th line from bottom, paragraph 135. 7th line from bottom, paragraph 135. The line starting from, if the reasons are not communicated, my lord. Has your lordship got it, my lord? If the reasons are not communicated to the government servant and the matter comes to the court can direct the reasons to be produced and furnished to the government servant. And if still not produced, a presumption should be drawn that the reasons were not recorded in writing and the impugned order would then stand invalidated. In the instant case also, my lord, a repeated request was made before this honorable court to give me full access to the records. They did not give. So therefore, now we'll have to presume that these records were, subsequently fabricated. Especially when, my lord, especially when in the first affidavit which they had filed on, my lord, 28/7/2022, containing 27 pages, there was not even a single whisper that the inquiry against me was dispensed with. It was only when the hearing commenced that they suddenly, my lord, manufactured a fresh ground that reasons have, that the inquiry has been dispensed with. This leads to the inevitable conclusion as well as the presumption that these records which have been subsequently sought to justify are, my lord, fabricated. And thereafter, my lord, next paragraph 11, they have quoted Jaswant Singh, where they said that the reasons has to be based on objective facts and not the outcome of whim and or caprice of the concerned officer. And by applying this ratio, my lord, the Honorable Court interfered. The Honorable Apex Court interfered. Now, my lord, I'll place some local judgments of this Honorable Court, my lord. Three judgments, my lord. One is, my lord, Ruben Kolita. I've already provided a copy, my lord. Ruben Kolita. Now, Ruben Kolita, the facts in a nutshell, your lordship will find at paragraph 3. The facts of the case are that the writ petitioner herein was joined as a constable under the CRP, so and so, my lord, after such. Now, in the year 2009, the Ministry of Home Affairs has raised 204 Cobra battalion of CRPF for being deployed against the terrorists, and petition name was proposed, and accordingly his services was placed under the Cobra battalion. While the petitioner was posted at Shivpur in Madhya Pradesh, he had gone to the market along with 200 other. It appears that in the evening there was a check roll call in the camp, and the second in command had alleged that the petitioner and his colleagues had consumed liquor. Accordingly, they were asked to subject themselves to a medical examination. At that, the petitioner had raised protest on account of which he was allegedly beaten by the superior officials. Now, if your lordship kindly turns to, my lord, paragraph, I'll just point out the paragraphs, my lord, 11, 12, 13, and I'll read out 17 and 18. Paragraph 11. Paragraph 11, my lord. Paragraph 11. Ruben Kolita.
Yes.
Paragraph 11. A plain reading of the impugn order dated so and so goes to show that the reason for not holding an inquiry is on the account of the fact that it was not reasonably practicable to hold such an inquiry. However, from a careful reading of the impugn order, I do not find any basis for recording the above reason. So, my lord, in that case, Ruben Kolita, it was in the termination order, they had recorded that the inquiry was dispensed with. Still, this honorable court said that we don't find any basis. And if your lordship kindly turns to the next page, paragraph 17. Paragraph 17, my lord, the operative portion of the judgment. Coming to the facts of this case, as noted herein above, the reason as to why the disciplinary authority had felt that it was not practicable to hold an inquiry against the petitioner have been recorded in the impugn order, and the same has been discussed. Applying the ratio of the decisions referred to herein above in the foregoing provision to the facts, this court is of the opinion that the reasons recorded in the impugn order was neither adequate nor relevant for the authorities to invoke clause B of Article 311(2) read with Section 11 of the CRPF and rule so and so of the CRPF rule and dismiss the petitioner from service without holding an inquiry. So the reasons, my lord, if we assume that these reasons have been, my lord, this purported reasons were there from before, even then they're neither adequate nor relevant, my lord. Just because they have to check, verify a lot of documents, so they cannot, my lord, shirk away from their duty to hold an inquiry. On this count also, my lord, the present writ petition is liable to be allowed, my lord, because the reasons are neither adequate nor relevant. And next, my lord, Ayush Tomar, another coordinate bench of this honorable court, my lord. Just 3 operative paragraphs I'll place. Paragraph 16. Paragraph 16, my lord.
Paragraph 16.
Paragraph 16, my lord. I'll just point out the relevant portion.
Yes.
Paragraph 16, my lord. The petitioner is facing trial in a criminal proceeding arising out of an FIR lodged by the authorities, but he is yet to be convicted. It may so happen that eventually the charge framed against the petitioner may be established in the criminal court. However, since there are allegations brought against the petitioner based on material security, principles of fairness and natural justice demanded that at least one opportunity was afforded to the petitioner to explain his conduct, which was apparently not given in this case. Therefore, this court is of the unhesitant opinion that the impugn orders have been issued not only in utter violation of the principles of natural justice, but also in the violation of the procedure led by the rules. These are the respective rules of that, my lord. And next paragraph. In the case of Ruben Kolita Supra, this court, while considering the law laid down by the Honorable Supreme Court in the cases of Tulsiram reported in so-and-so, Rina Rani reported in so-and-so, as well as Jaswant Singh reported in all of this, which I have placed before your lordship, has held that the reason as to why the disciplinary authority felt that it was not practicable to hold an inquiry against the employee must be properly recorded. However, as noted above, no proper reasons for dispensing with holding an inquiry against the writ petitioner in the opinion of this court finds mention in the impugn order. For the reasons, my lord, stated here in above, the impugn order was, my lord, are unsustainable in the eyes of law and therefore they are set aside. And the last judgment, my lord, another coordinate bench, Mohammed Hussain Ali, I have given a copy, my lord.
Huh?
I have already given a copy.
You've given a copy?
My lord, it is there, my lord. Mohammed Hussain Ali, my lord. 2022 5 GLD 263. These are the latest case laws, my lord, on this subject matter.
Yes.
My lord. My lord, if your lordship kindly turns,
One.
my lord.
Yes.
If your lordship kindly turns to paragraph 15, my lord. Paragraph 15. In paragraph 15, my lord, Tulsiram Patel was, my lord, discussed. And the ratio of the said judgment can be summarized as follows. And the ratio of the judgment was analyzed by this honorable court. And your lordship will see clause number 5, my lord. Clause number 5. The finality given to the decision of disciplinary authority by Article 311(3) is not binding upon the court so far its power of judicial review is concerned. And in a given case, the court can strike down the order dispensing with the inquiry as also order imposing penalty. So there is no, my lord, there's no, my lord, it's not binding upon this honorable court. Just because they have dispensed with doesn't mean your lordship cannot look into the manner in which it was dispensed with. And clause 6, my lord, writing reason for satisfaction that it was not reasonably practicable to hold the inquiry contemplated under 311 is a constitutional obligation. And if such reason is not recorded in writing, the order dispensing with the inquiry and the order penalty thereupon would both be void and unconstitutional. And the last clause, clause 8, my lord, the last clause, the next page. The reason of dispensing with inquiry need not contain detailed particulars, but the reason must not be vague or just a repetition of the language of the clause B of the second proviso. It cannot be vague, like in the instant case, that there were a lot of documents, we had to inspect a lot of documents, DP might be time consuming. It cannot be vague. And the paragraph 18, my lord, the last operative portion, the impugn order of dismissal nowhere reflects any reflection that it was not practicable to hold an inquiry. No assessment even was made to come to such a conclusion. No separate reason in writing for dispensing with the inquiry were recorded or preceded. Therefore, this court unhesitantly holds that while issuing the order of dismissal of the responsibility has failed to perform its constitutional obligation in as much as without there being any reason in writing, my lord. So ultimately, my lord, petitioner was reinstated with consequential benefits, my lord. These are the judgment, and just to summarize, I'll just place the factual matrix, my lord, once again. Just the important dates, I'll just for your lordship's recollection. I was appointed on, my lord, 21/2016.
1 minute.
My lord.
Yes.
I was appointed on 21/2016, my lord. Paragraph, page number 24, my lord, leaves room for no doubt that the Guwahati University service conduct rules apply. Secondly, my lord, I was arrested on 25/9/2021. On the same day, in a very hasteful manner, they terminated me at page 38. They terminated me at page 38, my lord, on 25/9/2021. Just one moment, my lord, if your lordship kindly takes up page 38 for one moment, my lord. Just for one moment, my lord. Page 38 is the impugn order.
Yes.
Page 38, initially they say that Chief Minister Vigilance Cell has arrested me, paragraph 1. And paragraph 2, the first 5 words, in view of the above. So the reason for my dismissal was my arrest at the time of issuance of the, my lord, issuance of the impugn order, and nothing more. Although now they want to subsequently improve upon the records by way of filing affidavit, my lord, but that cannot be allowed, my lord. 25/9/2021, my lord, I was given the impugn order. They don't even communicate this order, not even a copy earmarked. I was not even allowed to go inside the campus. I approached this honorable court. Your lordship had protected me, my lord, on 36/2022. 36/2022, this honorable court had stayed the termination order dated 25/9/2021.
Yes.
And the next important date, my lord, is 28/7/2022. 28/7/2022, authorities file an affidavit containing 27 pages. In those 27 pages, my lord, there is not a single whisper to the effect that the inquiry against me was dispensed with. Not even a single whisper, not even a single word. Thereafter, my lord, 25/7/2023, my services was regularized by this honorable court.
1 minute.
Well,
20.
my lord, 25/7/2023, my lord.
WBC.
My lord, WPC, my lord. 1 second, my lord. Page number 96. Page number
4271.
My lord.
Correct.
My lord.
4271.
My lord. My lord, 4271, my lord. Ordered a judgment and order dated 25/7/2023, my lord. Your lordship is correct, my lord.
You directed to be. Let us see the judgment.
Judgment. If your lordship kindly sees, my lord. That starts at running page, my lord, 92. And operative portion, your lordship will find at page 104, paragraph 19. For the reasons stated herein above, this court is of the opinion that all writ petitions must succeed and are hereby allowed. The writ petitions are therefore disposed of with the direction upon the respondents, more particularly the registrar, to process the cases of the petitioners in light of the observations made herein above, and thereafter take necessary steps for regular absorption and regularization of the service of the writ petitioners by issuing necessary office orders. Against this order, they had went to writ appeal, and they lost the writ appeal in that case. And my lord, after this regularization order, 27/2/2024, hearing of this matter commenced before this honorable court. And on 6/6/2024, they file an affidavit manufacturing fresh grounds. And the manufacturing of the fresh grounds, coupled with the fact that they have not given me access to the complete records despite several multiple requests, leaves room for no doubt that these grounds have been freshly manufactured. And my lord, even assuming for a moment, even I'm assuming that, okay, my lord, that these were not fresh grounds, even then they are neither relevant nor cogent nor adequate. And therefore, in light of the law laid down by the Honorable Apex Court, as well as the various coordinate benches of this Honorable Court, I've already placed those judgments before your lordship a little while ago. my lord, I've already placed. In light of that, my lord, even assuming that these were not freshly manufactured, even then, my lord, this cannot be sustainable in the eyes of law. These are my submissions with regard to the main case, my lord, and the secondly, my lord, contempt case. If your lordship kindly sees the next item, item number 3. We can continue after the. Placed all the facts before your lordship, and I've also placed all the judgments, my lord. And just to sum up, my lord, if your lordship kindly takes up the rules for one moment, my lord, the Guwahati High Court, my lord, Guwahati University Employee Service Condition Rules.
What rules?
My lord, Guwahati University Employee Service Conditions Conduct and Appeal Rules 1970, my lord. This is the rules which the respondents themselves admit that are applicable in the present case, as per my appointment order. And your lordship will kindly see, my lord, Rule 48. Rule 48. In fact, before coming to Rule 48, may I take your lordship to Rule 46, my lord? Rule 46 describes the nature of penalties. And my lord, Rule 46, 8 says, subclause 8 says, dismissal from service which shall ordinarily be disqualification for further employment. This is the most extremist form, most extreme form of punishment. So this is a major penalty. And if your lordship now kindly comes to Rule 48, the procedure, that procedure has been prescribed in Rule 48. They have to give me a show cause. They have to, my lord, 48.1 says, no order imposing on an employee any of the penalties specified in Rule 46 shall be passed except after an inquiry held as far may be in the manner herein after provided. And secondly, it says, my lord, the disciplinary authority shall frame definite charges on the basis of the allegations on which the inquiry is proposed to be held. Such charges, together with a statement of allegations on which they are based, shall be communicated in writing to the employee, and he shall be required to submit within such time as may be specified in the disciplinary authority a written statement of his defense, and also to since whether he desires to be hardened person. So this rule, my lord, when we read this rule with page number 24, page number 24 of the writ petition, my lord, page number 24, clause 5, page number 24, my lord, clause 5, my lord, they say the engaged candidates will have to follow the service conduct rules applicable for university employees. So there is absolutely no dispute with the fact that these rules apply in the present case, and they have somehow managed to bypass the entire procedure. And the affidavit which was initially filed, my lord, on 28/7/2022, nothing was stated. That affidavit containing 27 pages, nothing was stated that the inquiry was dispensed with. And it was only on the later stages of the final stages, my lord, they manufactured a fresh ground. Now, this is, my lord, insofar the first item is concerned, my lord. And the second item, my lord, if your lordship kindly takes item number 3 for a moment. Your lordship's order, your lordship will find, my lord, at page number 11. Page number 11, my lord. Item number 3, my lord. Connected matter. Item 3.
Contempt.
Contempt, my lord.
We are taking up the contempt also.
Because both are analogous, my lord.
Okay. Yes.
Page number 11, my lord. Paragraph 10. Page number 11, paragraph 10, my lord. Considering the aforesaid 3 reasons, comma, on a prima facie case being made out, the balance of convenience as well as the irreparable loss that the petitioner may suffer in the interim, it is provided that the notification dated 25/9/2021 terminating the petitioner from his engagement shall remain state until further orders. And my submissions, your lordship will find, my lord, at paragraph 9. Paragraph 9, my lord, page number 4. Paragraph 9, my lord, page number 4
Of the contempt.
of the contempt, my lord.
Yes.
That the facts and circumstances narrated herein above clearly reveals that the refusal to allow the petitioner to render his services is an act of willful and deliberate defiance of the order dated 30/6/2022 passed in WPC number 4393. The contender respondent has shown utter disrespect to this honorable court, thereby lowering the majesty and dignity of this honorable court. It is a clear case of willful and deliberate defiance of the order passed by this honorable court. As such, my lord, in the humble submission of the petitioner, this honorable court may be pleased to initiate contempt proceedings and be further pleased to, my lord, punish. And if your lordship kindly skips to, my lord, paragraph 10, that the contemptor respondent, despite due communication of the order passed by this honorable court, has completely failed to comply with the directions. The petitioner humbly states that such non-compliance on the part, despite due communications made by the petitioner, besides being yet another attempt to further harass the petitioner, amounts to absolute willful disobedience of the orders passed by the honorable court. And the next paragraph, my lord, paragraph 11, that the petitioner begs to submit that such non-compliance of the order passed amounts to interfering with the administration of justice and lowering the dignity and honor of this honorable court. Now, they have filed a response to that. They have filed an affidavit against that on 6/6/2024. And none of the statements and averments which have been made in the contempt petition, especially in paragraphs 9, 10, 11, and 12, have been denied either generally or specifically, meaning thereby they admit that as on that, my lord, they are guilty of contempt of this honorable court, and therefore, my lord, they should be punished under section 12 of the Contempt of Courts Act 1971, my lord. None of the statements and averments which I have pointed out have been denied by them, either specifically or generally, meaning thereby they admit. Subject to what my learned
Give me the contempt of course.
the lordship kindly sees section 12, my lord. Section 12. Read with Article 215 of the Constitution of India. Section 12. Willful and deliberate disobedience, my lord.
This is contempt case.
Contempt case, my lord, this contempt case 423 of 2022, my lord.
Yes.
My lord,
Upon you first come to the contempt.
my lord, we'll come to the contempt proceeding, my lord, little later. First, my lord, the writ petition and my vacating petition. Only thing is that, my lord, when the notice was issued in contempt petition, prior to that, my lord, notice was issued in the month of August, but in the month of July, we have filed affidavit in opposition as well as vacating petition. So at that time, my lord, there was an agreement in a bar that both would be heard together
the vacating petition as well as the main writ petition. So, my lord, I will come to that later. My lord. First, my lord, the writ petition. The first thing, my lord, that validity of that impugned termination order, whether it is in tune with the law laid down by the Supreme Court. First, my lord, my affidavit in opposition. It starts from page 44, my lord. It has been filed in July 2022. Writ petition was filed in June. This affidavit in opposition as well as, my lord, I has been filed in July. Contempt petition notice has been issued in August. Anyway, my lord, page 44 onwards, my lord. I will first draw your lordship attention to the annexures. Page 59. 3 annexures, my lord, very vital to the entire matter. Page 59, my lord, internal page 16, annexure 1. Now kindly see the first 4 lines. Office order. It was of 2016, my lord. And the termination order was issued in 2021. Which reference to the applications for the post of LDA and as per the recommendations of selection committee, page 59, my lord. In its meeting held on so and subsequent approval of the Honorable Vice Chancellor on so, following candidates are engaged as LDA in offices placed as shown against their names as given below. Serial number 3, Shashanka Soika, he is the writ petitioner, my lord. Secretary Office. Now next page. We can skip the other names, my lord. It is in another writ petition, my lord. That judgment was passed. Then my learned friend is wrong, my lord. Writ appeal has been preferred, challenging that order, my lord. And that writ appeal has not been disposed of as yet. Still pending. My learned friend's submission was that writ appeal has been closed. Not closed, my lord. Still pending. It is since it is in violation of the Guwahati University Act 1947, Section 44. Prior approval of the government, then we can regularize the services. Anyway, my lord, that is another aspect. The main crux of the matter starts from this engagement letter. Next page, my lord, page 60, internal page 70. First line, my lord. The engagement is subject to the following terms and conditions. I'll read slowly, my lord. Condition number 1. The engagement is on purely temporary and on contractual basis, initially for a period of 1 year and may be terminated at any time. It is important, my lord. May be terminated at any time without assigning any reasons thereof. The Supreme Court's judgment I will, my lord, place little later in Kumari Sri Lekha, my lord. There should be reasons in existence, but reasons must not be, my lord, shown, my lord. In the termination order, reasons have not been shown. I'll place the authorities later. Now we can skip other clauses. Clause 4, my lord. The engagement is subject to getting the character and antecedents to be verified from the police authorities. He has been arrested by the CM's vigilance. Anyway, now page 61. His engagement has been extended time to time. This is the last extension order, page 61, internal page 18, annexure 2. Office order dated 7 July 21, prior to his termination, 3 months prior to his termination. As per approval of the Honorable Vice Chancellor, Guwahati University dated so, the engagement of following LDAs on contractual basis are hereby extended for another period of 6 months. It is important, my lord. Another period of 6 months, which effect from the date as mentioned against their name. Serial number 3, Shashanka Soikia, the writ petitioner, Secretary Office, 1/7/2021. 6 months from that date. That means his term
has been extended up to 31/12/2021. And he was terminated on 25 September 2021. In between, my lord. Now, my lord, Annex 3, that impugn termination. Next page, my lord, page 62, internal page 90. Notification, Office of the Registrar, dated 25 September 2021. Within that 6 months period, my lord, action that period. This is notified for information of all concerned that the Chief Minister's Special Vigilance Cell has arrested Sri Shashanka Soikia, LDA, contractual, Office of the Secretary, University Classes, Sri Tridip Sharma, employee of ITI, working for so-and-so, Babylon Kakoti, security in charge, employee of Group 5 Placement Security Services, in connection with the APDCL recruitment test. There was a scam, my lord, regarding that APDCL recruitment test, and these 3 persons have been arrested by the Chief Minister's Vigilance. In view of the above, the service of Sri Shashanka Soikia, LDA, contractual, Office of the Secretary, University Classes, Guwahati University, has been terminated with immediate effect as per clause number 1 of the terms and conditions of his appointment order dated 21/2016. That clause 1, my lord. He can be terminated at any time without assigning any reason. Next parameter. Order, ITI Limited is hereby informed to terminate the service of Sri Tridip Sharma with immediate effect and make an alternative arrangement in place of him. Next para. Also, the security agency, that is Group 5 Placement and Security Services, is hereby informed to terminate Sri Babylon Kakoti with immediate effect. These 2 persons are, my lord, not read petitioner before this honorable court. Moreover, the entry of the above 3 persons is restricted, not barred, my lord, is restricted inside the Guwahati University campus henceforth. This is issued with the Honorable Vice Chancellor's approval dated 25/9/2021. This is the termination order which has been impugned by the writ petitioner before this honorable court. Now, kindly turn to my affidavit, my lord. Page, I'll skip some paragraphs, my lord. Page 8, internal page, and serial page 51. Same affidavit, my lord. Page 51, paragraph 6. Merit, my lord. Paragraph 6. With regard to the statements made in so-and-so of the aforesaid writ petition, while putting the writ petitioner to the strict proof thereof, this deponent humbly begs to state that the writ petitioner has submitted an application dated 2/3/2022 after expiry of his term of his contractual engagement on 31/12/2021 under the RTI Act, annexes Annexure J to the writ petition, which has been promptly responded by the PIO, Public Information Officer of the Guwahati University, through his reply communication dated 2/3/2022, same day, sent in speed post. But intentionally, the writ petitioner has refused to receive the same, which is clear from the note dated 7/3/2022 of the postal staff concerned, upon the envelope containing the said RTI reply communication as well as the relevant postal records in this regard. That has been refused, Miller. That RTI reply has been sent, Miller. That has been refused.
What was the query in the RTI?
Miller, regarding his service matter, Miller.
Okay.
Next para, Miller. Since it is not so much important to the core of the crux of the matter, Miller, that is why, Miller, I just mentioned. Next para. The writ petitioner during and even at the end of judicial custody period curiously has not approached the Guwahati University authorities concerned as regards the aforesaid termination of his contractual engagement, which engagement was to end on 31/12/2021. He was out in bail with bail, Miller. Bail was granted in November 2021, but his engagement was up to December 2021, but he has not approached the university authorities. which engagement was to end on 31 December as per term extension order dated so and so. Through his former colleagues, contents of the incident paragraph number 16 and 17 of the writ petition may be next page, referred to, and or through any postal communication without even resorting to entering the university campus for that purpose. Next paragraph. It is stated that though the writ petitioner has all along been in the know, rather well aware of the termination notification communication dated 25/9/2021, it is still in the official website of the Guwahati University for last several months, has embarked on the aforesaid RTI way on 2/3/2022 after more than 5 months, having his extended term of contractual engagement expired long back, and started filing representation dated 2/5/2022, so that principles of natural justice, etc. could be invoked, resulting extension of his term of contractual engagement to an indefinite period with initiation of a long-drawn departmental inquiry. Surprisingly, no appeal under the provisions of RTI Act has been filed as regards the purported non-response to the writ petitioner's RTI application dated 2/3/2022 till date. Now, next paragraph. Para 7. Page 53, internal page 10. It is important, Milord. Whether that Article 311(2) proviso, Milord, has been mentioned in the affidavit or not. My learned friend's contention is that not a whisper about that Article 311. It has been fabricated. But your lordship is aware, there are so many cases, Milord, that legal provision, whether it is mentioned or not, it is not necessary. But it is important whether that power could be exercised by the disciplinary authority or not. That is very important, Milord. Whether that article is mentioned or not, that 5 judges constitution bench, Milord. I will place the reliance, Milord, later. Anyway, Milord, that paragraph 7 is important in response to my learned friend's contention. That with regard to the statements made in paragraph number so and so, while putting the writ petitioner to the strict proof thereof, and also reiterating the statements made herein above, this deponent humbly begs to state that under the peculiar facts and circumstances of the instant matter, with the appertaining chronology of events, the writ petitioner is not at all prejudiced due to the termination of his contractual engagement with effect from 25/9/2021. And further, it is important, Milord, the writ petitioner is also not entitled to any protection under the provisions of Assam Services Discipline and Appeal Rules 1964 and or the inquiry provision under the Article 311(2) of the Constitution of India prior to the said termination. It is very important. The inquiry provision is not entitled, he is not entitled to the inquiry provision under Article 311(2) of the Constitution of India prior to the said termination, which has also been accepted by the Executive Council, the highest executive body of the Guwahati University, exercising its power under the Guwahati University Act 1947. Now, Milord, page 13, Milord. Internal page 13, serial page 56. Down below, Milord. Regarding suppression of facts. In the writ petition, he has not, Milord, stated that his term, contextual term, was to expire on 31/12/2021. That bail order has not been annexed, Milord. Later on, Milord, that bail order has been annexed after the filing of affidavit in opposition by the Guwahati University Authority. Anyway, Milord, page 56, down below, last para. This deponent humbly begs to state that as per the office order dated so and so, the writ petitioner's term of contractual engagement was extended for another period of 6 months with effect from 1/7/2021, and therefore his service term was to expire on 31/12/2021. Milord, after expiry of his term, Milord, he has moved this writ petition, Milord, in the month of June, after 6 months, Milord. But that was not, Milord, reflected my lord, in the writ petition. And the writ petitioner was no more in the service of the Guwahati University since 1/1/2022, which aspect has not at all been indicated by the writ petitioner in his writ petition, consequently suppressing a vital material fact from this honorable court. It's very vital, my lord. He is no more in the university service from 1/1/2022. But he filed the writ petition after 6 months in June 2022. Termination order was issued in September 2021, 9 months prior to this filing of writ petition. And at that time, at the relevant point of time, he was not in the university service as per earlier extension order.
When was the writ petition filed?
My lord, in the month of June.
Writ petition was filed on 27/6/2022.
27/6, last week of June.
This copy was not served, my lord. Not give a copy of the termination order itself. That is why we could not come. The moment we got, we immediately came before your lordship.
But he is a computer expert, my lord. Entire website, my lord, official website is displaying that termination order. He has filed RTI. He has not filed RTI appeal, my lord. Nothing at all.
In the impugn notification.
Anyway, my lord, I'll come to that later. The Supreme Court, what is the stand of Supreme Court regarding Article 311(2)? That is very important. Now, page 57. I am also not stressing so much about the suppression of facts. Otherwise, suppression of facts, my lord, he should have come with clean hand. That K.D. Sharma's case, Supreme Court, that is squarely applicable. We should not go into the details of in the merit of the case. This writ petition should have been dismissed in limine. But anyway, I'm just indicating. Page 57, internal page 14. On the other hand, service termination notification has also been issued with effect from 25/9/2021. As such, the matter has already become infructuous and of academic interest only. The writ petitioner, having been out of the service long back, without any discernible as well as conscious effort to move against the said termination in any forum, including this honorable court during the relevant period, and in view of the instant factual and legal metrics, it is humbly stated that this honorable court may not like to issue a futile writ, exercising the power under the Article 226 of the Constitution of India in the instant matter. He was out in bail in the month of November. His engagement was to expire on 31/12/2021. At least 1.5 months was there, but he has not moved this honorable court with a writ petition. He waited, Miller, and in the last week of June 2020,
He was out on bail on?
in November, Miller, possibly 17/11, 17/11/2021. I'll give the exact date later. In the month of November. Possibly my learned friend will help me in this case.
I'll give it.
This deponent, next parameter, page 57. This deponent humbly begs to state that as a part of a crafty design, the writ petitioner has recently moved the instant writ petition bearing WPC number so-and-so, the instant matter, with an intention to procure stay order as regards the aforesaid termination of his contractual engagement. And for that purpose in mind, the writ petitioner has willfully and intentionally suppressed some vital facts in the writ petition, which have got material bearings in the writ proceedings. It is stated that the Honorable Apex Court and the courts thereunder, including this Honorable Court, have on numerous occasions deprecated such practices in clear terms and propounded that one will have to come with clean hands before the court praying for any relief to be granted by the court. This deponent, in view of the aforesaid facts and circumstances, respectfully begs to state that the instant writ petition so-and-so may be dismissed in limine with cost. My lord, now, in view of this honorable court's direction, my lord, I have filed an affidavit, my lord, additional affidavit, that will be very, very vital in the instant matter, my lord. It starts from page 106. It was, my lord, signed by Dr. Hemanta Kumar Nath, Registrar in the disciplinary authority. My lord, kindly turn to para 3, my lord. 3, 4, and 5, my lord. Page 107, next page. I'll read slowly. The deponent humbly begs to state that an affidavit in opposition on behalf of the aforesaid respondents has already been filed on 28/07/2022, stating inter alia that after expiry of the extended term of contractual engagement long back, that is on 31/12/2021, the writ petitioner started filing representation for the purpose of initiation of a long-drawn departmental inquiry that with the appertaining, next page, my lord, that with the appertaining chronology of events, the writ petitioner is not at all prejudiced due to termination of his contractual engagement with effect from 25/9/2021, and further, the writ petitioner is also not entitled to any protection under the provisions of the Assam Services Discipline and Appeal Rules 1964 and or the enquiry provision under the Article 311(2) of the Constitution of India prior to the said termination. Also, it has been stated in the said affidavit in opposition that the writ petitioner has not indicated in his writ petition that his service term was to expire on 31/12/2021, consequently suppressing a vital material fact from this honorable court, and that the matter has already become infructuous and of academic interest on. Now, para 4. That the deponent humbly begs to state that this honorable court by an order dated 28/5/2024 in the aforesaid writ petition, so and so, instant writ petition, my lord, after hearing both the sides, has allowed the respondent Guwahati University to file an additional affidavit in opposition, indicating the reasons for dispensing with the inquiry, directing the matter to be listed on 6/6/2024. Now page 5. Para 5, my lord, next page. Page 109, paragraph 5. And last paragraph, my lord, very crucial to the writ proceeding, my lord. This deponent humbly states that in a note dated 25/9/2021 of the register to the Vice Chancellor of the University, prior to the issuance of the termination notification dated 25/9/2021, while inter alia stating that voluminous records of more than lakhs of OMR sheets were there in connection with the writ petitioner's police custody by CM Special Vigilance Cell, and that the writ petitioner's engagement is purely temporary and on contractual basis, initially for a period of 1 year, it has further been stated that, under quotation, my lord, in such situation, it is required that any such employee who happens to be engaged by Guwahati University immediately suspended, and search sheet is to be served upon him to start the disciplinary proceedings. However, this is not feasible to be done as he is presently in police custody, and the relevant records to be verified for the purpose of disciplinary proceedings could no longer be accessible for the university. Further, my lord, the records have been seized by the Special Vigilance Cell. Further, it is clear that the said DP will be a lengthy and time-consuming one, given the voluminous documents to be checked, while his engagement is valid only up to 31/12/2021, that is near about 3 months. Under the circumstances and given the situation, it is well nigh impossible or not feasible to start an inquiry against Mr. Shashank Soikia in the form of a departmental proceeding. As such, and being satisfied that no inquiry is feasible, kindly refer to Article 311, my lord. As such, and being satisfied. The writ petitioner has been sought to be terminated from service with immediate effect in the said note, which has subsequently been approved as recommended same day by the Vice Chancellor of the University, paving way for the issuance of the aforementioned termination notification dated 25/9/2021. It would be relevant to point out here that the entire exercise for the purpose of due termination of the writ petitioner's service on 25/9/2021 has been in tune with the provisions of Article 311 of the Constitution of India, including Article 311(2)(b, as well as Article 311(3) of the Constitution of India, as enunciated by Honorable Apex Court and the courts thereunder on numerous occasions in this regard, including the judgments rendered in Union of India and another versus Tulsiram Patel, that famous case, Miller, Constitution bench case, judgment, Miller, 1985 3 SCC so Constitution bench, as well as in Kumari Srilekha Vidyarthi and others versus State of UP and others, 1991. Next page. Page 111. Miller, I'll place the Miller the exact paragraph, Miller, little later. Tulsiram Patel and Kumari Srilekha. In this context, it may be stated here that the aforementioned Constitution bench has clearly held, relying upon the Oxford English Dictionary and Webster's Third New International Dictionary, that not reasonably practicable to hold the inquiry, as contemplated in Article 311(2)(b, it is important, Miller, is not a total or absolute impracticability. But what is requisite is that, it is under quotation, Miller, requisite is that holding of the inquiry is not practicable in the opinion of a reasonable man, taking a reasonable view of the prevailing situation. This is the law enunciated by the Constitution bench, that not reasonably practicable to hold the inquiry is not a total or absolute impracticability. Now, Miller, I'll try to be very brief, Miller. Article 311(2), the Constitution devotion.
Yes.
Article 311, the heading is possibly page 133. Article 311, dismissal, removal, or reduction in rank of persons employed in civil capacities under the union or a state. We can skip 1, Miller. Now 2. No such person, 2, Miller. No such person as aforesaid shall be dismissed or removed or reduced in rank except after an inquiry in which he has been informed of the charges against him and given a reasonable opportunity of being heard in respect of those charges, provided that where it is proposed after such inquiry to impose upon him any such penalty may be imposed on the basis of the evidence adduced during such inquiry, and it shall not be necessary to give such person any opportunity of making representation on the penalty proposed. Now it is important, provided further that this clause shall not apply. We can skip A and C, Miller, the B, clause B, Miller. Where the authority empowered to dismiss or remove a person or to reduce him in rank is satisfied that for some reason to be recorded by that authority in writing, it is not reasonably practicable to hold such inquiry. For some reason to be recorded by the authority in writing is not reasonably practicable to hold such inquiry. As per Supreme Court, Miller, reasons must be there, but it should not be reflected, it may not be reflected in the impugn termination order or final order. But reasons must exist, and without those reasons, my lord, termination order could not be issued, my lord. Now, 3 is also important, my lord. The satisfaction part, my lord. 3. If in respect of any such person as aforesaid, a question arises whether it is reasonably practicable to hold such inquiry as is referred to in clause 2, the decision thereon of the authority empowered to dismiss or remove such person or to reduce him in rank shall be final. The decision of the authority empowered shall be final. Now that Tulsiram Patel case. First. Only 3-4 paras. That article 311(2), that proviso has been beautifully explained, Miller. I will skip some paragraphs, Miller. The relevant paragraph. Miller, first, Miller, paragraph 126. I'll read the whole paragraph, Miller. Paragraph 126, page 500, Miller. As pointed out earlier, the source of authority of a particular officer to act as a disciplinary authority and to dispense with the inquiry is derived from the service rules, while the source of his power to dispense with the disciplinary inquiry is derived from the second proviso to Article 311(2). There cannot be an exercise of a power unless such power exists in law. So the exercise of power must exist in law. The 311(2) second proviso. If such power does not exist in law, the purported exercise of it would be an exercise of a non-existent power and would be void. Last 3 lines, Miller. Non-existent power and would be void. The exercise of a power is therefore always referable to the source of such power and must be considered in conjunction with it. The court's attention in Salappan case. Next page, Miller. It was also a famous case, Miller, that was distinguished in this case, Miller. Salappan case was not drawn to this settled position in law, and hence the error committed by it in considering Rule 14 of the Railway Servants Rules by itself and without taking into account the second proviso to Article 311(2). It is also well settled that where a source of power exists, the exercise of such power is referable only to that source and not to some other source under which that power exercised. The exercise of such power would be invalid and without jurisdiction. Similarly, if a source of power exists by reading together 2 provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it as an order passed under both those provisions. Further, even the mention of a wrong provision, it is important here. Further, even the mention of a wrong provision or the omission to mention the provision, omission and wrong provision, omission to mention the provision which contains the source of power will not invalidate an order where the source of such power exists. So that termination order does not contain Article 311(2) second proviso. That won't invalidate that termination order. But that power must be there, reason must exist. They have not challenged the power of the disciplinary authority, whether register can issue that termination order or not. That is another aspect. Since they have not challenged, Miller, so it's all right, Miller. So that part I won't delve upon this. Now, next 6-7 lines, my lord. Important, my lord. Some cases have been referred, my lord. The omission to mention, last 6-7 lines, my lord. The omission to mention in the impugn orders the relevant clause of the second proviso or the relevant service rule will not, therefore, have the effect of invalidating the orders, and the orders must be read as having been made under the applicable clause of the second proviso to Article 311(2), read with the relevant service rule. It may be mentioned that in none of the matters before us has it been contended that the disciplinary authority which passed the impugn order was not competent to do so. Now we can skip the other para. Now para 130. Page 503, meter. Para 130, meter. Yes. Page 503. Only 2-3 paragraphs I will read out, meter. 130. The condition precedent for the application of clause B is the satisfaction of the disciplinary authority that it is not reasonably practicable to hold the inquiry contemplated by clause 2 of Article 311. What is pertinent to note is that the words used are not reasonably practicable and not impracticable. According to the Oxford English Dictionary, practicable means capable of being put into practice, carried out in action, effected, accomplished, or done. Feasible. Webster Third New International Dictionary defines the word practicable inter alia as meaning possible to practice or perform, capable of being put into practice, done or accomplished, feasible. Further, the words used are not practicable but not reasonably practicable. Webster's Third New International Dictionary defines the word reasonably as in a reasonable manner to a fairly sufficient extent. Now the Supreme Court's Millard opinion. Thus, whether it was practicable to hold the inquiry or not must be judged in the context of whether it was reasonably practicable to do so. It is not a total or absolute impracticability which is required by clause B. What is requisite is that holding of the inquiry is not practicable in the opinion of a reasonable man, taking a reasonable view of the prevailing situation. Millard, some instances are given, Millard. We can skip, Millard. Now, paragraph 134. It is very, very important, Millard, regarding whether reasons should be reflected in the termination order or not. The first 4 lines, Millard. Then other lines are, Millard, explaining that position. Millard. Para 134, page 505. It is obvious that the recording in writing of the reason for dispensing with the inquiry must precede the order imposing the penalty. Next sentence. The reason for dispensing with the inquiry need not therefore find a place in the final order. It is very important. The reason for dispensing with the inquiry need not therefore find a place in the final order. Reason may not be there, but the Supreme Court opines it would be usual to record the reason separately and then consider the question of the penalty to be imposed and pass the order imposing the penalty. It would, however, be better to record the reason. In the final order in order to avoid the allegation that the reason was not recorded in writing before passing the final order but was subsequently fabricated. Miller, the opening line is, however, be better. It is not mandatory, but it would be better, Miller. Otherwise, Miller, that termination order won't be invalidated. Only for that cause, Miller. The reason for dispensing with the inquiry need not contain detailed particulars, but the reason must not be vague or just a repetition of the language of clause B of the second proviso. For instance, it would be no compliance with the requirement of clause B for the disciplinary authority, simply to state that he was satisfied that it was not reasonably practicable to hold any inquiry. Sometimes a situation may be such that it is not reasonably practicable to give detailed reasons for dispensing with the inquiry. Next page, Milord. This would not, however, per se invalidate the order. It is important, Milord. This would not, however, per se invalidate the order. Each case must be judged on its own merits and in the light of its own facts and circumstances. Now, paragraph 138. Page 507. Where a government servant is dismissed, removed, or reduced in rank by applying clause B or an analogous provision of the service rules, and he approaches either the High Court under Article 226 or this court under Article 32, the court will interfere on grounds well established in law for the exercise of power of judicial review in matters where administrative discretion is exercised. It will consider whether clause B or an analogous provisions in the service rules was properly applied or not. The finality given by clause 3 of Article 311 to the disciplinary authority's decision that it was not reasonably practicable to hold the inquiry is not binding upon the court. The court will also examine the charge of malafidis, if any, made in the writ petition. In examining the relevancy of the reasons, the court will consider the situation, which according to the disciplinary authority made it come to the conclusion that it was not reasonably practicable to hold the inquiry. If the court finds that the reasons are irrelevant, then the recording of its satisfaction by the disciplinary authority would be an abuse of power conferred upon it by clause B and would take the case out of the purview of that clause, and the impugn order of penalty would stand invalidated. In considering the relevancy of the reasons given by the disciplinary authority, the court will not, however, sit in judgment over them like a court of first appeal. It is important, Milord. In order to decide whether the reasons are germane to clause B, the court must put itself in the place of the disciplinary authority and consider what in the then prevailing situation a reasonable man acting in a reasonable way would have done. The matter will have to be judged in the light of then prevailing situation and not as if the disciplinary authority was deciding the question whether the inquiry should be dispensed with or not in the cool and detached atmosphere of a courtroom, removed in time from the situation in question. Now, the last sentence, Milord. It has some vital implications in the instant matter, Milord. Where two views are possible, the court will decline to interfere. Now, we can turn to another judgment, Milord, explaining these two views and interpretation of the Milord, this clause, Milord. West Bengal Central School Service Commission, Milord. Regarding these two views, Milord, interpretation, Milord. It will clarify, Milord. West Bengal Central School Service Commission and others, 2019, volume 18, SCC, page 39. We can directly go to paragraph 30, Milord. Last two pages, Milord. Page 45. Regarding these two views aspect, Milord. The Constitution bans in Tulsiram Patel said, where two views are possible, the court will decline to offer. Now, what the West Bengal Central School Commission case said, Milord? Paragraph 30. In exercise of its power of judicial review, the court is to see whether the decision impugned is vitiated by an apparent error of law. The test to determine whether a decision is vitiated by error apparent on the face of the record is whether the error is self-evident on the face of the record or whether the error requires examination or argument to establish it. If an error has to be established by a process of reasoning on points where there may be reasonably be two opinions, there, my lord, words are two views, Tulsiram Patel, now here two opinions. It cannot be said to be an error on the face of the record, as held by this court in Satyanaran Lakshminarayan Hegre versus so-and-so, if the provision of a, it is important, my lord, last line, my lord. If the provision of a statutory rule is reasonably capable of two, next page, my lord, of two or more constructions, and one construction has been adopted, the decision would not be open to interference by the writ court. It is only an obvious misinterpretation of a relevant statutory provision or ignorance or disregard thereof, or a decision founded on reasons which are clearly wrong in law, which can be corrected by the writ court by issuance of a writ of certiorari. Next page, Miller. Next parameter, 31 and 32. The sweep of powers under Article 226 may be wide enough to quash unreasonable orders if a decision is so arbitrary and capricious that no reasonable person could have ever arrived at it. The same is liable to be struck down by a writ court. If the decision cannot rationally be supported by the materials on record, the same may be regarded as perverse. 32. However, the power of the court to examine the reasonableness of an order of authorities does not enable the court to look into the sufficiency of the grounds. Sufficiency of the grounds in support of a decision to examine the merits of the decision, sitting as if in appeal over the decision. The test is, it is very, very important, my lord. The test is not what the court considers reasonable or unreasonable, but a decision which the court thinks that no reasonable person could have taken, which has led to manifest injustice. The writ court does not interfere because a decision is not perfect. So the note, my lord, the background reasons for dispensing with the inquiry, it is clear, my lord. It might be, my lord. I could agree to some extent with my learned friend's, my lord, submission. But if the decision is imperfect, if there are two views, if there are two opinions, then this Tulsiram Patel and this West Bengal case is clear, my lord. This court won't see whether it is perfect or imperfect, but it should not be perverse. It should not be in violation of the statutory laws. So, my lord, the view, the opinion of the Guwahati University Authority is clear, my lord. He should have been, my lord, in the university service up to 31/12/2021. Only 3 months left. There are voluminous, my lord, records, more than lakhs. My lord, the entire records are with the vigilance cell. And he is only in contextual, my lord, engagement. And the term of the engagement, that he could be terminated at any time, my lord. That phrase has been used, my lord. At any time, without assigning any reason. Then what the Supreme Court in Kumari Sri Lanka says, my lord? Only to that judgment I will refer, my lord. I will place reliance, my lord. Yeah. You don't need. Kumari Sri Lekha Vidyarthi and others, State of UP and others, 1991, Volume 1 SEC, page 212, paragraph 13, Miller. It was regarding the engagement of government advocate and their termination. Paragraph 13. It was argued on behalf of the UP Millard, State Government Advocate General Millard. The starting line starts from Advocate General Contention Millard. May I read Millard entire paragraph? Paragraph 13, page 231. The learned additional Advocate General contended that clause 3 of para 7.06 says that the appointment of a district government council is only professional engagement terminable at will on either side and not appointment to a post under the government. And the government has the power to terminate the appointment at any time without assigning any cause. That was the contention of additional Advocate General. He contended that this power to terminate the appointment at any time without assigning any cause and a clear statement that the appointment is only professional engagement terminable at will on either side is sufficient to indicate that the relationship is the same as that of a private client and his counsel. In our opinion, this provision has to be read not in isolation, but in the context in which it appears and along with the connected provisions already referred to. The expression professional engagement is used therein to distinguish it from appointment to a post under the government in the strict sense. This, however, does not necessarily mean that a person who is not a government servant holding a post under the government does not hold any public office and the engagement is purely private with no public element attaching to it. This part of clause 3 of para 7.06 means only this and no more. The other part of clause 3, which enables the government to terminate the appointment at any time without assigning any cause, can also not be considered in the manner suggested by the learned Advocate General, Additional Advocate General. Now it is important, Miller. It is, Miller, in the context of the present case, Miller. Last 5 lines, Miller. 7 lines. The expression at any time merely means that the termination may be made even during the subsistence of the term of the appointment. The contextual appointment, Miller, of the writ petitioner. The expression at any time merely means that the termination may be made even during the subsistence of the term of appointment and without assigning any cause means without communicating any cause to the appointing whose appointment is terminated. We have not, Miller, communicated with the writ petitioner with any reason, Miller. It is clear, Miller. Without communicating any cause to the appointee whose appointment is terminated. However, without assigning any cause is not to be equated with without existence of any cause. It merely means that the reason for which the termination is made need not be assigned or communicated to the appointee. It was held in that famous case, Miller, Constitution Bench case. Next page, Miller. It was held in Liberty Oil Mills versus Union of India, 1984 case, Miller. That the expression without assigning any reason implies that the decision has to be communicated, but reasons for the decision have not to be stated. But the reasons must exist. Otherwise, the decision would be arbitrary. We can skip the other sentences. Reasons must exist, but the termination order that may not be reflected. So here, Miller, similarly, Miller, termination order was issued. Article 311(2) has not been, Miller, mentioned, and that reasons have not been expressed. But in spite of that, Miller, it cannot be, Miller, invalidated only for that those 2 reasons, Miller. Miller, that is my submission, Miller. And regarding existence of reasons, my affidavit is clear, Miller. And if there are 2 views, if it is imperfect on the Guwahati University authority to take a decision that inquiry is not required, Then, my lord, since there are two views, my lord, two opinions, it may not be perfect, my lord. I agree, my lord, to some extent. But since, my lord, it is not a perverse decision, my lord.
When was the decision taken dispensing with the discipline?
On 25th, my lord.
Within
itself.
24 hours.
Where that?
My lord, that affidavit, my lord.
No, the records.
My lord, records are here. Your lord has asked for the record, my lord, on the last occasion, my lord. It was isolated. I have a photocopy of it, my lord. I have already shown to my learned friend, my lord, this page, my lord. This is a note from the register, the disciplinary authority, to the vice chancellor, my lord. And it has been placed in the executive council meeting. May I read, my lord? To the Honorable Vice Chancellor, Guwahati University, issued by the register. Subject matter regarding Shashanko Soikia. With reference to the matter of Mr. Shashanko Soikia in connection with his police custody by CM Special Vigilance Cell in relation to indulging in alleged illegal practice as regards scanning of the OMRs for appointment by the APDCL, who is a contractual employee working in the office of the Secretary University Classes, Guwahati University, the following is apprised. Along with said Mr. Shashanko Soikia, one Mr. Tridit Sharma, an employee of so-and-so, Mr. Babylon Kakuti, working for so-and-so outsourced security agency, were also taken into police custody as per report in the same case on same allegation. The allegation against them is that they have been involved in assuring jobs to many candidates in whose OMR sheets were being scanned in the office of the Secretary University Classes. Moreover, voluminous records of more than lakhs OMRs are there in this connection. In respect of Mr. Tridit Sharma and Mr. Babylon Kakuti, communications have been made to the concerned agencies to immediately terminate and remove them from Guwahati University service. They are outsourced personnel. We are not concerned with this Tridit and Babylon. Now it is important, my lord. In this connection, it is stated that the engagement letter issued to Mr. Shashanko Soikia by the office order under so-and-so dated 21/2016 categorically states, among other terms and conditions, that the engagement is on purely temporary and on contractual basis initially for a period of 1 year and may be terminated at any time without assigning any reasons thereof. The candidate shall have no claim for regular appointment against any permanent post by virtue of his engagement. The engagement is subject to getting the character and antecedents to be verified from the police authorities. Next parameter. In such situation, the opinion, my lord, the formation of opinion, my lord, in this context, my lord, whether it is perfect or imperfect, my lord, it is another thing. In such situation, it is required that any such employee who happens to be engaged by Guwahati University be immediately suspended, and charge sheet is to be served upon him to start the disciplinary proceeding. However, this is not feasible to be done as he is presently in police custody, and the relevant records to be verified for the purpose of disciplinary proceedings could no longer be accessible for the university, since it is in the police custody. Further, police has seized the entire OMR sheets, more than lakhs. Further, it is clear that the said DP will be a lengthy and time-consuming one. Since lakhs of OMRs, the scanning of OMRs, that is the main allegation. So that scanning of more than lakhs of OMRs. So in the departmental proceedings, that will have to be done, and it is in the CM's vigilance cell. And further, he is in police custody at that relevant time. Further, it is clear that the said DP will be a lengthy and time-consuming one, given the voluminous documents to be checked, while his engagement is valid only up to 31 December 21. That is near about 3 months. It is well nigh impossible, my lord. Within 3 months, my lord, DP has to be initiated, charge sheet has to be drawn, he has to be given time, my lord. Then, my lord, inquiry officer is to be engaged. Then, my lord, trial, my lord, then this evidence, my lord. After that, my lord, that DP will be concluded, my lord. And he will be under suspension, my lord. So, my lord, more than 3 months, my lord. Under the circumstances and given the situation, it is well nigh impossible or not feasible to start an inquiry against Mr. Shashanka Soikia in the form of a DP. As such, it is important. The conclusion, my lord, in the context of these, my lord, things, my lord. As such, in order to maintain the sanctity and robustness of the examination system, and thereof being satisfied that no inquiry is feasible, Mr. Shashanka Soikia, whose term of engagement is expiring on 31/12/2021, may be terminated from service with immediate effect as per relevant condition of his contractual engagement. For kind approval with suggestion, if any. It has been, my lord, written by the registrar, who is the disciplinary authority, to the vice chancellor, and vice chancellor in the left side, my lord, approved as recommended. Then it has been placed before the executive council. And
Where is the executive council?
my lord, it is not here, my lord. It is only, my lord, this part, my lord. But in my affidavit,
When
my
did
lord,
the executive council take the decision?
my lord, immediately in the next sitting, my lord, not on that day, my lord. Since my lord, executive council sits, my lord, around my lord, 2-3 months duration interval, my lord. In my affidavit is clear, my lord. That was not rebutted by my learned friend.
When did the executive council take a decision?
My lord, exact date, my lord. No, it has been placed, my lord, but I cannot give the date right now, my lord. And the vice chancellor has the, my lord, authority and, my lord, legal, my lord, authority as per section 8 of the Guwahati University Act.
Section 8 of?
8 of Guwahati University Act.
What is that?
Guwahati University. Local X volume 5. Using volume 5. Fourth edition, volume 5.
Yeah. 1947.
47.
Yes. I have. Section?
Section 8, my lord, volume 5 to yes. That emergency power, my lord.
Section 8.
Section 8, my lord. Volume 5 to 9.
No, section 8 is power and duties of officers. 6.
8A, my lord.
8A.
Capital A, my lord. Volume 5. Say. Yeah. Eight A, the vice chancellor, my lord. Capital A. And 8B is the powers and duties of the vice chancellor. 4, my lord. Vice chancellor shall be the principal executive, my lord. And 4, in any emergency, which in the opinions of the vice chancellor requires
8A.
8B, my lord. 8B.
8B.
Capital B, my lord. Paragraph 4, my lord. if in any emergency,
8B1.
8B4, my lord.
No. 8B1.
Emergency power, my lord. One is regarding, my lord, his principal, executive, and
No,
academic.
8B14, isn't it?
Not 1-4, my lord. 8B4.
Here it's written 1.
My lord,
8B. I don't know.
this one, my lord. May I read, my lord?
Anyway.
May I read, my lord?
Mm.
8B, my lord, 4, my lord.
Mm.
Numerical 4, my lord. In any emergency, which in the opinion of the Vice Chancellor requires that immediate action should be taken, the Vice Chancellor shall take such action as he deems necessary and shall at the earliest opportunity thereafter report his action to the officer, authority or other body who or which in the ordinary course would have dealt with the matter. Now 7, my lord. Last clause, my lord. The Vice Chancellor shall exercise such other powers as may be prescribed by the statutes and ordinances. So, my lord, he has got that emergency power. He, my lord, approved the action, my lord, and it has been, my lord, placed before the Executive Council for appraisal, my lord. এখন বেশি ক্লিয়ার আছে হ্যাঁ লিখিয়া না
Oh.
Since the register,
There's something wrong in this. I think it's the old one.
Since the register is the disciplinary authority and the Vice Chancellor is superior to him, my lord. So, my lord, they can take, my lord, decision regarding termination as per those legal provisions. And since, my lord, two opinions, two views, perfect or imperfect, my lord, whether it is a perverse order, whether it is a totally unreasonable, total violation of any statutory law, then it would have been different, my lord, domain. But since, my lord, the context is clear from that note, my lord, appended in the record, my lord. So, my lord, the termination order is valid, my lord. That Article 311(2)(b) second proviso is fully applicable. Those Sri Lekha, Tulsiram Patel, West Bengal, Central Commission judgment. You know, I have already given some 5-6 judgments, my lord, regarding suppression of facts and other things, my lord. But I am concentrating focusing only on that Article 311(2) second proviso. Whether university decision is perfect or perverse, whether there is any biasness, my lord. If there is any biasness element, my lord, then, my lord, that register of Vice Chancellor should have been named, my lord, by named, my lord, they should have been implicated. That was not done. And one other thing, my lord, that the Tulsiram Patel case, my lord.
Yes.
And then Tulsiram Patel case, my lord. that very-
Tulsiram.
Yes, my lord.
Mm.
That constitution bench judgment, my lord. Referring Maneka Gandhi and Liberty Oil Mills. All are, my lord, constitution benches, my lord. Maneka Gandhi, 9 judges, Liberty Oil Mills, 7 judges, Tulsiram Patel, 5 judges. All are constitution bench, my lord. Referring those Maneka Gandhi, Liberty Oil Mills cases, my lord. Paragraph 102. We may take recourse of this, my lord, provision, my lord. This paragraph, my lord. 102, page 480. Bail order dated
18,
11.
2021 pleaded at paragraph 11 of my affidavit in reply.
Bail order was granted on 18/11/2021. Out in bail on 18/11/2021.
Para?
My lord, it is, my lord, 18/11/2021, paragraph, page number 11 of my affidavit in reply filed on 8/8/2022.
Running case. Yeah. I'm moving.
Internal page 11 of the affidavit in reply filed on 8/8/2022.
Running page?
My lord, running page,
You have not marked it?
I don't have this. my
1
lord.
minute.
Paragraph 8,
Affidavit in reply.
affidavit in reply filed on 8/8/2022, my lord. Paragraph 8,
1 minute.
my lord.
8/8/2022.
My lord. 8/8/2022, my lord. Paragraph 8, subparagraph 3.
Immediately after my affidavit in opposition.
Paragraph 8.
Subparagraph 3. Not immediately, much 1 year prior.
Para 8.
Para 8, subparagraph 3, my lord.
Paragraph. This court granted the
Granted bail.
This court.
Yes, because
So my submission was that, my lord.
Yes.
He was arrested on 25/9. He was granted bail on 18/11. And his engagement came to end on 31/12/2020. Within these 3 months, my lord, he was granted bail in November. But he approached this honorable court after near about 8 months, more than 7 months, my lord, in June, last week of June, on 27th. Already, he was no more in the university service. It's a futile writ, my lord. If we consider, my lord, that aspect, my lord, it's a futile writ. And if we consider that K.D. Sharma's case, my lord, suppression of vital facts come with clean hands, my lord, then this writ petition goes, my lord. Regarding bail, my lord, he was mum, my lord.
When did he approach this court?
On 27/6/2022. He was terminated on 25/9/2021. He was granted bail on 18/11/2021. His contextual term expires on 31/12/2021. And he approached this honorable court on 27/6/2020. When he was no more in the university service. The futile writ, my lord, just academic interest, my lord. There are so many cases. And regarding this suppression of fact, my lord, both these vital facts, my lord, he have not, my lord, explained or indicated
and I am taking Milord, my learned friends praise Milord, not a whisper about these two vital aspects, Milord, regarding granting bail or regarding expiry of his terms, contextual terms, not regular employment. Milord, page 480, Milord, Tulsiram Patel case, Milord. Paragraph 10.
1 minute.
For argument's sake, I accept it may be an imperfect decision on the part of government. But whether it is a perverse decision, whether it violates any statutory law, that note is clear, Milord. It is not a perverse decision, Milord.
Yes.
Tulsiram Patel, again, Milord, only one aspect, Milord. Paragraph 102. That may be a way out for my learned friend. Page 480, paragraph 102, that constitution bench judgment, Milord, Tulsiram Patel. May I read? In this connection, it must be remembered that a government servant is not wholly without any opportunity. Rules made under the proviso to Article 309 or under acts referable to that article generally provide for a right of appeal, except in those cases where the order of dismissal, removal, or reduction in rank is passed by the president or the governor of a state, because they being the highest constitutional functionaries, there can be no higher authority to which an appeal can lie from an order passed by one of them. Thus, where the second proviso applies, though there is no prior opportunity to a government servant to defend himself against the charges made against him, he has the opportunity to show in an appeal filed by him that the charges made against him are not true. Now, this is important, referring the constitutional bench judgments of Maneka Gandhi and Liberty Oil Mills. This would be a sufficient compliance with the requirements of natural justice. In Maneka Gandhi case and in Liberty Oil Mills versus Union of India case, the right to make a representation after an action was taken was held to be a sufficient remedy. And an appeal is much wider and more effective remedy than a right of making a representation. So, we still have that right, Miller, in view of this paragraph 102. Appeal
What
to
do
the
you say?
central-
What do you say about clause 5 of the appointment order of the petition?
Clause 5, Miller. Page 20. My affidavit, Miller.
No.
That appointment order, Miller. Initial appointment order.
Yes.
My affidavit, Miller.
It
Page-
may be in your affidavit or it's in the writ petition or
Same, Miller. Page 59 and 60.
or page 24. Anyone.
Miller. Page 60, Miller. I'll refer to my affidavit in opposition.
Mm.
Since it's my affidavit in opposition, Miller. So, Miller, page 60, Miller. 6 terms and conditions, 6 clauses, Miller. The engagement is subject to following terms and conditions. So 1 is regarding at any time which is assigning any reason. 4 is regarding character and antecedents to be verified from police authorities. Now he was in police custody, Miller. Now 5. Engaged candidates shall have to follow the service conduct rules applicable for university employees. So, Miller, that Calson's, Miller, hierarchy, that Balwant Singh case, Miller, first constitutional provision, then, Miller, that statutory, then, Miller, that rules and other thing, then notification, Miller, then where, Miller, 311 to second proviso, Miller. If we apply 311.2, we should not go to those other things, but the service condition rules, it is also, Miller, not, Miller, against the constitutional law. It cannot be, Miller. Otherwise, it will be a total legal anarchy. Miller, first, Miller,
What do you mean?
Miller, first constitutional law, Miller. Then, Miller, we will have to go to do that notification or those rules, Miller, framed by the university.
But there's already a terms and conditions at clause
Miller.
5. that the candidate shall have to follow the service conduct rules of the university.
Miller, it is applicable. It is natural, Miller, obvious, Miller.
So it is applicable, isn't it?
Yes, Miller, applicable.
Then your university conduct rule says what?
Miller, conduct rules, Miller, since Miller, he is a contextual employee, not a permanent employee. So, Miller,
Because why I'm asking this question?
Miller,
Why I'm asking this question
Miller,
is because in the note of the register,
Miller,
there's no mention of Article 311,
Miller.
nor the service conduct rules of Guwahati University. That part you'll have to clarify.
Tulsi petal is clear, Miller. I'll again read that parameter. That will clarify the position.
Let us see again.
Tulsi petal clarified. Funded paragraph 130. Sorry.
There 126.
126.
Yes.
Very important, Miller. May I read, Miller? Only that parameter. Regarding the exercise under Article 311 or other rules. Page 500, Miller, para 126. As pointed out earlier, the source of authority of a particular officer to act as a disciplinary authority and to dispense with the inquiry is derived from the service rules, while the source of his power to dispense with the disciplinary inquiry is derived from the second proviso to Article 311(2). The first one regarding derived from service rules, source of power to dispense with the disciplinary inquiry is derived from second proviso, Miller. Third and fourth sentences, lines, Miller. There cannot be an exercise of power unless such power exists in law. If such power does not exist in law, the purported exercise of it would be an exercise of a non-existent power and would be void. The exercise of a power is therefore always referable to the source of such power and must be considered in conjunction with it. The court's attention in Salappan case, next page, Miller, was not drawn to this settled position in law, and hence the error committed by it in considering Rule 14 of the Railway Servants Rules by itself and without taking into account the second proviso to Article 311(2). It is also well settled, important, Miller, where a source of power exists. The exercise of such power is referable only to that source and not to some other source under which were that power exercised. The exercise of such power would be invalid and without jurisdiction. Similarly, if a source of power exists by reading together two provisions, whether statutory or constitutional, and the order refers to only one of them, the validity of the order should be upheld by construing it as an order passed under both those provisions. If there are two provisions, Miller, then if one refers only one provision, then, Miller, both provisions would be applicable, Miller. It would not invalidate that termination order. Now, next line, Miller. Next sentence, Miller. It is very, very important, Miller. Further, even the mention of a wrong provision or, that is important, Miller, mention of a wrong provision, Miller, 9th, 10th line, Miller. Further, even the mention of a wrong provision or the omission to mention the provision which contains the source of power will not invalidate an order where the source of power, such power exists. So that note may not reflect, may not contain, may not include that Article 311(2) or any service rules. It won't invalidate, Miller. Constitution bench is clear. Then, Miller, those case laws have been referred. Now, Miller, last 5-6 lines, Miller. The opening line, Miller. The omission to mention in the impugn orders the relevant clause of the second proviso or the relevant service rule will not, therefore, have the effect of invalidating the orders, and the orders must be read as having been made under the applicable clause of the second proviso to Article 311(2), read with the relevant service rule.
It may be mentioned that in none of the matters before us, Miller, it is not important. It is regarding disciplinary authority. So, Miller, it is clear, Miller. If one omits to mention Article 311 or any service rule, then it won't invalidate. Clear, Miller. 4 or 5 sentences have been used by the Honorable Apex Court.
Okay.
So, in our note, it is not reflected, but it won't invalidate. But reasons are there, Miller. And it is not perverse decision, Miller. It may be not perfect, but perfect and imperfectness, Miller, this Honorable Court won't see. But reasons must be there. And that is clear from the note, Miller, which has been, Miller, issued by the disciplinary authority, which is not in dispute, Miller. Registrar is the disciplinary authority, and superior authority, the vice chancellor, he has approved, Miller. Miller, that is my submission. And regarding that contempt, Miller,
Yeah, contempt.
since, Miller, that in the bar, Miller, that was an agreement, and some orders also reflect, Miller, that position, Miller, that both the IA as well as writ petition would be hard to.
What was there in the IA?
Stay vacation.
Stay vacating.
Yeah, that's why.
That's
What,
Miller,
what
that-
were the grounds for the vacation of the
Miller,
state?
the almost same, Miller. Miller. Miller, paragraph Miller 9, it starts from page 12, Miller. IA C 2241 oblique 2022. Page starts from page 12, Miller, paragraph 9, down below, Miller. Marriage.
Page 12.
Page 12, Miller.
Yeah.
Paragraph 9. That the applicants humbly begs to state that in the appertaining.
That is a different thing. About that is for suppression, isn't it?
Miller, from 1 onwards, Miller. 9 subpara 1 onwards, Miller. Up to page 15, Miller. 13, 14, 15, Miller. Married, Miller. 13, 14, and 15. Almost all the grounds taken in the affidavit in opposition, Miller, also included in that IA. Page 13, 14, and 15.
Okay.
And also paragraph 10 and 11. Basically, Miller, paragraph 9. So, Miller, when this honorable court took up the IA, then there was an agreement that entire matter should be heard together. So that was the reason, Miller, up to final hearing, Miller, that contempt petition, Miller, it has been taken together, Miller. We have also filed affidavit to that contempt petition, that it would be heard together.
What is stated in the contempt?
That it would be heard together, Miller. That was my main contention.
There was no agreement that the orders will not be complied with. I had not consented to any such order, my lord. That the orders of this court would not be complied with. There was no agreement at the bar. I'm just clarifying, my lord.
Lord, page 15, Miller. My affidavit filed on 6 June 2024. Paragraph 4, Miller, 4 and 5, Miller. May I read, Miller? Page 17, Miller. That will clarify the situation, Miller. Paragraph 4, Miller, page 17. That the deponent humbly states that immediately thereafter, respondent Guwahati University has filed affidavit in opposition so and so, as well as interlocutory application for the purpose of vacating, modifying, etc. of the aforementioned interim stay order dated 30 June 2022 in the writ petition, which interlocutory application and unconnected writ petition are still pending before this honorable court. However, in an order dated 9th August 2022, it is important, Miller, as passed in the said IA, this honorable court stated that it is stated by the learned counsel for the parties, Miller, my learned friend was also there, Miller, that while deciding the question as to whether to modify or vacate the interim order, the entire issue raised would have to be gone into, which may tantamount to a final decision in the writ petition. Next page, Miller. Accordingly, the learned counsel prefers that the matter be fixed for a final hearing on an early date. As agreed, Miller. List on 18th August 2020. Both sides.
No, but you have not given the reasons. Why you have not
Exactly.
reinstated the petition?
Yes, Miller, since Miller, we have filed vacating petition.
No,
That you are-
vacating petition must file prior to the filing of the contempt. All right.
Exactly.
He filed the affidavit,
Miller,
you filed the IA,
Miller.
and when this order was passed, thereafter the
Exactly.
petitioner filed the contempt.
Miller.
In the contempt, you filed the affidavit
Exactly.
stating that in the IA, this order has been passed because of this.
Miller.
You could have at least said that as the petitioner was no more in
Exactly.
in the contractual engagement after 31/12/2021.
Miller.
2021,
Exactly,
no?
Miller.
2021.
My IA is clear, Miller. Everything has been stated.
Your IA is a different issue. But in the contempt, when you file your affidavit, you could have at least given that clarification.
Exactly. Miller, in the contempt petition has been tagged along with the writ petition, IA, everything, and all the parties.
Maybe it is tagged, but these are all independent petitions.
But
In the IA, order was passed whether to modify or to vacate. It may have an impact on the merit of the case. So
Miller,
it will be
since
taken up.
Miller, all the parties agreed, Miller, that word very important, Miller, agreed that it would be hard together. That means, Miller, compliance of that order, Miller.
You don't get my point. You filed your affidavit in the writ petition.
Miller.
You filed the IA.
Miller.
After that, the order in the IA was passed.
Miller.
And it was listed on 18/8/2022.
Miller. Exactly.
Correct.
Miller.
In the meantime, after that order was passed,
Hmm.
petitioner filed the contempt.
Miller.
And you have filed your affidavit.
Miller.
So in your affidavit, you have said in the IA, this orders has been passed.
Miller.
Correct.
Miller.
In para 4.
Miller.
You could have added one more paragraph in your reply, saying that in the meantime, petitioner is no more under the contractual engagement of the Guwahati University authorities with effect on 31, and therefore we are not in a position to bring him back. That could have been at least said, and you have not tendered any apologies, also nothing is there.
Miller,
No unconditional apology, nothing.
Nothing. Miller, one.
That is one aspect. This
Miller, one vital aspect, Miller. Since Miller order has already been passed, whether he was in service or not, without modifying that order, Miller, if I put forward that ground that he is no more in the service, then understand, Miller, since order has already been passed, stayed, Miller. So that is why, Miller, this IA has been referred, Miller.
That's why, so Fukan, you don't get my point. Order was passed on 25/9/2021, correct? Terminating the petitioner.
Miller.
Your ground is in July.
Miller.
You extended the service of the petition up to December. In the meantime, this thing happened.
Miller.
So you have dispensed with the DP
Miller.
and terminated his service.
Miller.
All right. He was under police custody. He got his bail in November 2021.
Miller.
Then he kept quiet.
Miller.
Then in only sometime in June of 2022, he filed a writ petition.
Miller.
Now, this court was not aware of the fact that the petitioner's contractual engagement had already expired.
Milord, in that case, Milord, I crave your lordship, Milord, since Milord, affidavit in opposition to that contempt proceeding has not been filed as yet. In view of this, my
No. My lord, your lordship will not allow them to improve upon the records, my lord.
No, not
He's
regarding
been
improving.
repeatedly trying to improve upon the records by one affidavit.
You have already filed your affidavit.
This
in
is the final stage of hearing, my lord.
Not affidavit, Milord. Milord, regarding contempt petition is not final, Milord. It has been tagged.
That's why it is
Milord.
tagged.
So, Milord, I still have the right, Milord. That affidavit in opposition, Milord. Possibly, Milord. It's my misconcept of, Milord, the proceedings, Milord. Possibly, Milord.
See,
But for my, Milord,
in a
misconcept,
contempt,
Milord.
in a contempt,
Milord.
there's an allegation that the order passed by this court has not been complied with by you.
Milord, I agree.
That's all.
Milord, that's
Nothing
all.
much.
Milord.
All the petitioner's duty is bring it to the notice of the court that the order passed by this court has not been complied.
Milord.
Now it's your turn to answer.
Milord.
In that answer, you have correctly said affidavit was filed on so and so day, IA was filed on so and so day, and then this court passed the IA with the agreement that the matter should be taken up at an early date, and the matter was fixed on 18/8/2022. Up to that stage, it's all right. But then you should have explained why you could not comply with the court's order. Why you could not comply with the court's order? At least one paragraph you could have said was, by the time the petitioner approached the court by way of filing the writ petition, despite his termination order, he had also completed his contractual engagement. And therefore, when this court passed to state that termination order, still then we could not reinstate the petitioner back into service because his contractual engagement was no more there. That part you could have added, plus you could have said, given your unconditional apology, at least one line. That aspect you did.
I agree, Milord. There is some sort of misunderstanding on my part, misconcept of law on my part, Milord. So, Milord, I crave leave of your lordship to at least file an affidavit, elaborate affidavit in opposition. Milord, since, Milord, the affidavit I have just referred, Milord, it is only an affidavit stating that all parties agreed. Nothing more, Milord. Regarding that contempt petition, Milord, in that affidavit in opposition, Milord, I will, Milord, place those grounds, Milord.
Don't argue any further on this.
Milord, since it is the contempt petition is not in the final stage, Milord.
This is not done, Milord.
In writ petition, Milord, it is only in for admission stage, Milord.
This is not done.
In admission stage, in the writ petition, Milord, in the contempt petition, Milord, no order has been passed that it will be in the final stage of hearing. And this cause this also reflects, Milord. It is in the admission stage. But we agreed that in the admission stage itself, Milord, that writ petition along with I.
I'll make my reply now.
To that contempt proceeding, Milord, that will be a different thing, Milord. But in writ petition, Milord, my submission.
We are disposing of all.
Yes.
There's no point.
Now, my lord, firstly, let me clarify my stand with regard to the contention that there has been some suppression of fact. Your lordship will kindly come to my.
He was not pressing.
If he's not pressing, then I'm
He was not pressing seriously on the suppression of fact. He was more on Article 31 to 311.
In that case, I'll not reply because no point in wasting time, my lord.
Yes.
I'll not reply. Now, my lord, second case. Now, since that suppression, I need not reply. I'll take your lordship directly to the because he has argued extensively for 1.5 hours, my lord. I was awaiting that he will come to the main point, but unfortunately, my learned friend didn't. Now, what is my case? What is my case before your lordship? It's a simple case. I was, my lord, I was initially appointed on 21/2016, page 23, my lord. Your lordship has seen. Time to time, every year, my lord, 6 months, I was given extension. I was all throughout, I was working in Guwahati University, my lord. And due to the issuance of the impugn order dated 25/9/2021, the termination order, that is the only reason why my services were not extended thereafter, my lord. And that is why I have come before your lordship. And this order of 25/9/2021, my lord, a bare perusal makes it abundantly clear. It is an out and out stigmatic order. My entry is also restricted, my lord. They don't give me a copy. They say they have published in some website. My lord, from when did the government started publishing termination orders in website, my lord? I am the victim. I'm being sought to be terminated. You give me my termination letter, my lord. It's as simple as that. Instead of doing that, my lord, they published in some website. And which website? What is the name of that website? What is the screenshot of those websites? They've not even annexed. They say they have given in some website. Which website, my lord?
That aspect has not been clarified. We have already served, my lord. That aspect has not been, my lord. I have submitted, my lord.
Not
some portions of my affidavit.
Not even a copy has been earmarked.
That aspect has been clarified.
If you're,
Since Milord, if you're
let me complete. You have had your say for 1.5 hours. Let me rebut.
regarding that aspect, Milord, I will have to respond.
Let me rebut.
Whether that termination order has
For
been
1.5
served or not.
hours, my learned friend had argued. Let me. I'll not take 1.5 hours. I'll only take 10 to 15 minutes. Now, if your lordship kindly turns to my lord, paragraph, page number 10, my lord, of my affidavit in reply. Affidavit in reply dated 8/8/2022. 8/8/2022, my lord. Page number 12. My affidavit in reply. Page number 12, my lord. Paragraph 5.
Dated
My lord, 8/8/2022, my lord. Affidavit in reply filed on 8/8/2022.
page.
Page 12, my lord. Internal page 12. My lord, with regard to the statements made in subparagraph 7.5, the petitioner humbly begs to state that the statements and averments made in paragraphs 11, 12 makes it abundantly clear the services of the petitioner was extended from time to time since his initial date of appointment, that is 21/2016. It was only after the issuance of the impugn notification dated 25/9/2021 that his services were not extended. The services of other LDAs who were appointed and working along with the petitioner pursuant to the advertisement dated 17/4/2012 are continuing to render their services as on date. This in establishes that there has been an infringement of Article 14 and 16. He is saying it's a futile writ. My lord, I fail to understand how has this writ petition become a futile writ, especially when there's an interim order staying the impugn order, my lord. How is this a futile writ? He says it's an academic exercise. They have played with a person. They have imposed an extremely stigmatic order without even giving him an opportunity of hearing. His services have been, my lord, were extended from the 2016 since he joined. And he says it's in futile writ. No, I think this is a completely misconceived, my lord, argument. It's completely fallacious to say that this petition has become a futile writ. And
Bharat, don't go too much into the facts. We have already
facts are simple,
on the question.
very
of
simple.
Law, you can reply.
Yes. And my lord, law, I'll just say, my lord, there's one thing I want to say. They say he can be terminated any time, but they cannot terminate a person with an extremely, because the Pavendra Narayan judgment, Narayan, my lord, that judgment I have placed, my lord, Supreme Court, where the word stigma has been defined. It is there with your lordship, my lord. It is there. Pavendra Narayan Verma. Pavendra Narayan Verma, my lord.
Give the quotation.
My lord, 2002 1 SCC 520. Paragraph 29.
2000.
My lord, 2002 1 SCC 520. 2002 1 SCC 520, my lord. I have given a copy. Pavendra Narayan Verma. Paragraph 29.
What? I'm not getting it.
My lord. It is there, my lord. I have given a copy, my lord.
Today?
It was there from before only. I checked the file, it was there, my lord. Pavendra, Tadal of Side.
2002 1 SCC. Must be in this bunch. Let's pick up. Is it in this bunch or in the other?
Maybe in the other also, my lord, because it's a Manupatra citation I have given. I placed it very early. Pavendra Narayan. Pavendra Narayan Verma. Or your lordship can have my copy only. There's no problem. I've given my copy only. Asen. Oh, Pavendra Narayan Verma, no? Asen? Okay. If your lordship kindly turns to paragraph 29, my lord. Paragraph 29.
Para 29?
Para 29, my lord. Pavindra Narayan Verma.
Oh, there's no para 29. It ends with para 28. How does it start? Maybe this is Manupatra, isn't it?
My lord, my lord.
You are holding which one?
My lord, before considering the facts of the case before us, one further, there's a line.
Which para?
Your lordship can have my copy only.
Do you have another copy?
Well, I don't have, but then I'll just point out. It says that what language in a termination order would constitute stigma. Now, when, my lord, if
One minute, 1 minute. Sorry. No. This is different. This one is different. Oh, 1 minute. Where was it? Maybe it's not Parvendra Narayan.
anyways, I'll just point out. So in that, my lord, the question was that what language in a termination order would constitute as stigma? Now, my lord, anything which imputes a person above the mere unsuitability of the job would amount to stigma, my lord. In my case, they don't say I'm unsuitable for the job and they've left. I mean, you kindly leave. That is not the language. In my case, my lord, there have been allegations of misconduct and they have gone to the extent of restricting me. So they have imposed upon me a lifelong stigma. This stigma is going to be attached to me for whole life. And therefore, they could not have dispensed with an inquiry under 311(2). Now, if your lordship kindly sees, my lord, just for a moment, the affidavit in opposition which has been filed by my learned friend on 28/7/2022, page 10 thereof. Now, this was the initial stand of the government. Affidavit in opposition, paragraph 10, my lord, filed on 28/7/2022, page number 10. Now, if your lordship sees, my lord, page number 10, paragraph 7, internal page 10. Has your lordship got it, my lord?
Yeah.
Now, in that paragraph 7, it says that with regard to the statements made in paragraphs 18, 19, 20, 21, 22, 23, 24, and 28 of the further petition, while putting the petition to the strict proof, and also reiterating in the statement that the deponent humbly begs to say that under peculiar facts and circumstances of the instant matter with the appertaining chronology of events, the writ petition is not at all prejudiced due to the termination of his contractual engagement with effect from 25, and further it is also not, and further the writ petition is not entitled to any protection under provisions of article Assam Discipline Appeal Rules 1964 and the inquiry provision under article 311(2) of the Constitution. Prior to the said information, which has been accepted by the Executive Council, the highest executive body of the Guwahati University, exercising under the Guwahati University Act 1947. Now, my lord, initially this stand was 311(2) is not applicable to the petitioner. This is what my learned friend had stated. But in this entire affidavit, my lord, your lordship will not find a single whisper to the effect that the inquiry itself has been dispensed with. And that is why, my lord, when we initially started the argument, we started from Purushottam Lal Dhigra, Article 14, 16, 19, 1G. Now, during the course of the argument, my lord, this is what the stand has come. They have changed their stand, which the latest stand your lordship will find at page number 109.
That I've seen.
109.
Let's conclude.
This is the main issue, my lord.
Let's conclude.
This is the main issue. Only two reasons, my lord, they have stated. One is that voluminous, time consuming, they have to go through papers. And my last submission on law point, my lord, after Tulsiram Patel, my lord, lot of judgments of Supreme Court and coordinate benches of this honorable court has come. And all of them say it has to be objective. Based on objectivity, it has to be adequate, it has to be relevant, it has to be proper. That's all, my lord.
Let me say, okay, Barol, and counsel for the petition. Also, Mr. PG Foucault, standing counsel. Guwahati University. For the respondents.
Civil court.
You have four respondents.
1 and 2.
Only two. Only two respondents. For the respondents, one and for all the respondents.
For only two respondents. All the rest.
Hearing concluded, just one minute. You have a photocopy of this?
My lord.
Just give me a photocopy. I don't want to keep the original records.
I think your lordship will record this, my submission that they have, despite multiple requests, they never shared the records with me, my lord.
The one thing, my lord, that termination order has been, my lord, communicated by post, my lord. And under section 27 of General Process Act, my lord, there are so many cases, my lord, I have not cited, my lord.
Anyways, that
The
is
postal
under,
communication under section 27 is enough, my lord.
doesn't matter.
Whether he receives it or not.
Whether he receive it or
So
not.
many cases, my lord. I own, my lord.
Only thing is
disturb your-
legality and validity of 25 minutes. And for your lordship's convenience, shall I give a list of dates, my lord? A written argument in short? I'll give it to the court master, my lord.
When can you give it?
My lord, tomorrow, my lord.
Okay.
Yes.
Just a list of dates.
You want to give?
No, my lord. Since, you know, list of dates, my lord.
Short, actually list of dates.
Short, my lord, that written arguments, my lord, can be allowed to, my lord, file. Written arguments.
You want to file?
Yes, my lord, written arguments.
Or if not required, it's not required.
Okay, then do one thing. Don't say hearing concluded. But so and so, so and so. List the matter again on it. And that did no arguments. Just
it may be concluded, my lord.
okay,
Since, my lord,
conclude. Hearing conclude.
at a length, my lord, my lord, another day, my lord.
Okay.
Obliged, my lord. I'm really obliged to your lordship for the.
That contempt petition, it is pending, my lord.
No,
Oh,
I'm
no.
disposing
My
it.
lord.
Obliged for the patient hearing, my lord.
We'll
Obliged.
see what happens.
Deeply obliged.
Most of
Four.
May I please, your lordship?
What is this matter?
Lordship, they have filed, lordship, government have filed an affidavit, lordship, additional affidavit. We need to reply, lordship. We have filed an
When did you file the who filed the additional affidavit?
lordship, government and filed.
Government has filed.
On
When?
on
When?
7/8/24, your lordship.
Hmm?
On 7/8/24, they have filed an additional affidavit, lordship. The government. Weeks time, lordship.
Okay, Mr.
P. Chakraborty, lordship.
P. Chakraborty, learned counsel for the petitioner. Placed for weeks time to file reply to the additional affidavit filed by the respondent. Number 2. Please. After 1 week. You want a date?
The date may be given.
1 week will be when? Today what? 12. 20.
Oh, obliged, your lord.
5 and 3.
My lord.
Yes, we can't take up.
My lord, I understand. My lord will fix it any other day. Convenience to this honorable court. I leave it. I understand. My lord is tired. I will not press, my lord. And indeed, my lord is convenient.
The part of matter, my lord. So let it be very
My lord,
sorted. Let it be very sorted.
Yes, sir. So, my lord, at your convenience, my lord will fix it. No, I have no problem, my lord.
No,
Okay,
I have problem, but I have problem. He does not have problem. I am suffering. I have problem. My lord, let it be sorted, very sorted. Let it be on.
But this Sharma learned counsel for the petition. As well as Mr. Abidale and the standing counsel IID G. for the respondents, 2 to 5. List the matter for further hearing.
On
17
24th, my lord.
Sorry.
On 24th.
No, no,
I
it is too late, my lord. It is too late, my lord. It is low. Other again, there is examination. November again, examination will start again. One semester will expire.
They are
So let it
already
be
in
19th
between
September.
classes, my lord.
My lord, let it be 19th September, my lord. Otherwise, very delay. Already very. It already
I
delayed.
have 2 matters. on
Let
that
it
day, my lord,
19th
to argue,
September. Let it be. Let
I
it.
have 2 matters to argue.
Other matters
Come
will
on,
wait.
sir. No, that is not the point, my lord.
My lord, the thing is that
I'm
it is
not.
parted matter.
Okay, we'll keep it on 19.
Mind, my lord.
19th,
If it is not
I'm
possible.
not pressing to anything because I
19th.
understand, my lord. I'll
Can
finish
it be? Can it be top of the list, my lord?
That will
That
come
day
out.
we will figure it out.
Huh?
That will
19th.
come, it's the
Well,
parted material
Part
come
will
out.
come.
Parted
Come
matter.
as it-
Yes, sir.
Oblige, my lord.